All right, good morning, everybody. My name's Cliff Hammond. I've got a number of our labor and employment experts here today. We thank you for joining us. We've got a nice program I hope that you'll enjoy. It's about the 2025 labor and employment topics that you might need to navigate that you didn't even know were happening. Some of these are going to be refreshers, but a lot of new stuff has happened this year, so much so that a lot of our attorneys are just constantly keeping up on this and calling clients, talking to clients, reading cases, looking and updating and refreshing different agency opinions. And so what we've tried to do today is we've got a number of our attorneys on a roundtable, and we're going to ask them some questions on different topics. We've broken it up into different topics, have some of our experts talk about different issues. And if you have any questions, what we're going to do is we ask that you come on and put any chat that you have, anything that you want in the Q&A section. If you take a look on your Zoom, you'll see there's a Q&A section. Go ahead and put it in there. There's two different areas. There's a chat and a Q&A. But what we've noticed is if we have people going in both, we miss some. And we're not going to be able to get to every single question. And we're probably going to have some questions that, frankly, you're going to give you that attorney speak that says, hey, it depends, because it actually does depend. And so we don't want to get in front of 158, 200 people and start going through your own particular issues and somehow void that attorney-client privilege. That wouldn't be good for anybody. But we are going to try to touch base on some of these developments, because I can tell you every year it seems like, okay, this was a wild year, but next year will calm down. Not this year. This year's another one of those ones. So what we're going to do is we're going to start off first with my partners, Rob Hammer and also Tony Delamonte. I work with both of these gentlemen a lot. And one of the things that I've noticed, and I've talked to a lot of clients about this, since the beginning of COVID, I have seen personally, and I think Tony can probably tell you the same thing, more non-compete and non-solicitation cases come across our desk than in the 20 years that I had combined before then. And that is significant, because it seems like every week we get one at least where we're either helping someone who wants to hire somebody but has a non-compete or non-solicitation or a confidentiality agreement, or we're going after somebody who went down the street and wants to compete. And so we've seen a ton of these lately. We're seeing them go more. There's been some changes. So I want to kind of turn first to Rob and say, Rob, good morning. Thank you for joining us here, and for everybody out there.
Good morning, Cliff. Thank you for having, and thank you everyone for attending today.
Right. So can I ask you to start it off, what's the difference between a non-compete agreement and a non-solicitation agreement? They sound pretty similar. What's the
Sure.
difference in those two?
Sure. And as you said, we've been getting more and more calls on these sorts of topics, and you're having a clear understanding of which avenue you want to go down, or even both, is a really good starting point in order to figure out, how you can protect your legitimate business interests. So, first of all, a non-competition agreement is a restrictive covenant that a person would sign that basically says, hey, I agree that I am not going to, if it's drafted correctly, directly or with someone else, right? Engage in activity that competes with your line of business, right? Has to be within a certain geographic scope, has to be within a certain timetable, right? And it has to be reasonable. And we'll kind of get into those tests and those requirements later on in our conversation. But you can think of the non-competition as the broad restriction. Hey, you know what? I taught you how to do X, Y, Z, or I have a secret formula in how to do X, Y, Z. I have a special way of putting mayonnaise on the bread, is what Jimmy John's argued, a few years back when they tried to enforce a non-competition agreement. But it's basically restricting someone from operating within that industry. Okay. Non-compete basically restricts someone from operating in the industry. A non-solicitation agreement is a little bit more narrowly focused, right? What that says is, hey, you know what? You can compete in the industry, but you're not going after my clients, my employees, my vendors, right? Whatever happens to be included within that scope of that particular agreement, right? So non-compete is that very broad restriction. Hey, I'm not, you're not allowed to be in the industry at all. Find a new career. Non-solicitation means, yes, I'm going to allow you to operate within the industry, but my client listed all the people that you knew about, you can't contact them, right? And how you describe that becomes a very interesting topic, right? Because let's say you have a non-solicitation agreement, you say, hey, you can't contact any of my existing clients, now or in the future. Well, are you going to keep the person up to date with your entire client book on an ongoing basis, right? I mean, how do you navigate those sorts of issues? And those sorts of items are what we're going to be talking about in a little bit more detail today.
So just kind of off the top, a little bit for people that aren't familiar with these things, I just have a question for you. If I have an employee and they're a pretty good employee and they know all my other employees and they know who's good and they know who's bad. And let's just say I don't have a non-compete against them. They can go work for my competitors or anywhere down the. Is there a way that I can say, well, if you go get my customers, then that's on you and whatever. But can I stop them from taking my employees with them, the good ones? Can I write something in a agreement like a non-solicitation to stop that?
Yeah, I mean, look, there's what you're talking about is basically like a no poaching provision, right? You're not going to take my employees, you're not going to bring, people over. And yeah, can you use a non-solicitation agreement for it? Maybe, right? There's certain, enforceability questions. It also begs some antitrust questions depending on the size of your company. The agreements that say, hey, you know what, you're not going to hire my people may invoke antitrust issues depending on the scope and duration and the size of the company. But yeah, I mean, restrictions on going after existing employees, going after existing vendors, things like that is a fairly common use of non-solicitation agreements.
So you've got your don't compete against me.
Mm-hmm.
You've got your don't take my customers and clients, right? Because you have the inside knowledge. And then you have the maybe don't poach some of my employees. So under what circumstances would one agreement be better than the other?
Sure. Well, I think it's a business by business analysis, right? It's also a provision by provision analysis, right? I think every person in the world would say, hey, an agreement that my employees sign that they will never compete with me, they will never solicit, they will never do anything to harm my business for the next 500 years is the best thing that we could ever hope for, right?
Mhm.
The reality is it may not be enforceable, right? So you have to really look at your business and what you are trying to protect, right? If you have a business that has very highly technical information, particularized processes, things that aren't, generally commonly known, especially if you're training people, right? And again, assuming you have reasonable restrictions, right? It has to be tied to the scope of the business, where you're operating, how long, and assuming that those boxes are checked, a non-compete agreement generally gives a little bit broader protections for a company. On the other hand, if you have generic processes, we always talk about the Jimmy John's example, right? When they tried to enforce a non-compete agreement for people that were, making sandwiches and putting mayonnaise on bread, right? A non-solicitation may be a little bit more likely to be enforced. And again, as we'll get into, the courts view the enforceability of the agreements a little bit differently. So it really does need to be a company by company analysis, a business by business analysis. And then there's also market conditions, right? Finding good help is hard. And people that are in high demand know that they're in high demand, and they may have some negotiation leverage to say, hey, you know what? I'm not going to sign a non-competition if you want me to come work for you. I don't want to be barred from the industry, or I don't want the risk that I'm going to have to fight this later on. I'll agree not to go after your people, right? But I'm not going to agree to be out of the entire industry if I decide to leave your employment. And the other
And
thing
that's a good
is,
point, though,
yeah,
right? I mean, you just said, I think, hit the nail on the head. It's the market conditions. In
mhm,
'07 and '08 here in Michigan, I mean, people were begging for a job. People were being
yeah,
laid off. We had an outrageously bad economy where people were looking for jobs, moving out of the state. During COVID, one of the reasons why I said that we have so many is probably because of the fact that people were being paid to stay home. and could work from their nice cottage up north or Florida or whatever. And we're like, yeah, maybe I won't come. So there was a need to try to protect the employees and try to get these enforced as they are. Now we're where we're at now. And so it may have changed, but you did
Correct.
want it changes
Correct.
now,
And
right?
and also understand, the agreements aren't mutually exclusive, right? It's not uncommon, especially in some of the business work that I do in the transactional work, to include both a non-competition and a non-solicitation provision, right?
Yeah. So we can mix and match or a little bit, right? Okay. So when, Rob, can you ask an employee to sign a non-compete or a non-solicitation? When can you do that?
Well, you can ask them to sign it anytime you want, right? Whether or not they will or it's enforceable are two different things, right? So, typically speaking, we see non-competition, non-solicitation agreements being solicited at the start of employment, right? It's part of the standard agreements, or it's part of the negotiation package, right? You can also see those arise, based on fundamental transactions, right? If the company's bought and sold, right? People may have updates and refreshes to the employment agreements, right? You can also see it on the exit side. We're going to get into separation agreements later on in today's session, right? But as a condition of separating from the company and getting X number of dollars, it may be an appropriate position, right? Courts have said that continued employment is sufficient consideration, generally speaking, for
Even at will?
even
Even
at
at
will.
will?
Yeah.
Okay.
Yep. Yeah, sufficient consideration for the enforcement. Now, obviously, facts and circumstances. There's very few safe harbors and very few bright lines, right? I'm sure that a court is going to look at the agreement a little differently if you had them sign the non-competition in the middle of their employment and 30 seconds later you fire them afterwards. Yeah, may have a little bit of an issue with enforceability under the facts and circumstances, and Tony will talk about that here in a little bit. But again, you could ask, an employee to sign the non-competition or non-solicitation agreement at any point in time. Whether they will, that's a different story.
Right. Okay. Well, thanks, Rob. I got a question for you, Tony, just to jump in here. And it's an interesting one about how can a non-compete be challenged, right? So we have lots of business circumstances, like Rob was talking about why you draft it. But what are some of the things that you're seeing, that you've seen, that are out there where people can say this non-compete and this non-solicitation is not worth the paper it's written on? What are we looking at for those type of issues?
Yeah, and as you and I both know very well, these agreements can be challenged, and they are frequently challenged all the time.
Mhm.
Now, what that means, whether it's a lawsuit, whether you get a nasty letter from either side saying, hey, I've got this non-compete, you jumped across the street, you're ruining my business, or hey, you made me sign this non-compete, it's not enforceable. You're prohibiting me from making a living. It's overly broad. It's not reasonable. There's arguments on both sides of it, but they are frequently challenged all the time. And I think a year ago we were yelling from the rooftops, "Hey, this FTC rule,
Yeah.
watch out! Non-competes are going to be banned." Well, that was struck down by a Texas district court. I think the FTC has appealed that. So they're still in litigation. That FTC rule is still banned, which means that in Michigan, non-competes are still enforceable. That being said, again, as you know very well, Cliff,
Mhm.
there's a sort of practical side to it too, and judges look at non-competes very differently, depending on the facts and circumstances, like Rob mentioned. So, in general, Michigan courts apply a rule of reason. So, under Michigan statute, restrictive covenants are enforceable only if they're reasonable, and that word does a lot of heavy lifting. So, the courts will look at four things. They'll look at, does the employer have a reasonably competitive business interest worth protecting? So is that trade secrets, specialized training, confidential information, customer goodwill? It has to be something more than just avoiding competition and preventing someone from going down the street. So that's number one. Number two is the duration reasonable? So is it a non-compete for 6 months or a year or 2 years? Or is it 10 years? I'll tell you, I think courts would probably strike down a 10-year non-compete. the third is the geographic scope tailored to where the employee actually worked and where the company does business. So again, kind of looking at the big picture. If you're a sales company and you've got a national presence and you've got sales executives working accounts all across the United States, a non-compete that has a nationwide scope might be reasonable.
Mhm.
If you're a Michigan car dealer, for example, and you work within a 15-mile radius, a national, non-compete probably isn't going to be enforceable. And then the last thing is the type of work or the line of business that's being restricted. So, do you write in the agreement, hey, you can't work in the automotive industry, selling, manufacturing, whatever, or is it just so broad that you're preventing someone from working in that industry at all? So these are the things that courts will look at when they assess the reasonableness of a non-compete. And courts can blue line the agreement, so they don't have to throw the whole thing out. They can rewrite it essentially to make it more reasonable. So to answer your question, yes, they're enforceable in Michigan. That's what the courts look at. They're challenged all the time, but the analysis is very fact intensive and depends on the situation.
So right now, I think you hit the nail on the head, though. There was last year when we were talking to clients, there was a federal law or a federal rule that was coming out from the Federal Trade Commission that was effectively going to ban most non-compete agreements. That's not happening right now, and it probably won't be happening anytime in the near 3 years. While the current administration's in there, could happen, but most likely not. I've heard there's a law that's pending here, a bill that's pending in the state house. That's not going anywhere, I assume, if they can't figure out how to pay the bills.
Yeah.
Uh,
Every single year they introduce that bill.
that thing's coming. There's a bipartisan bill at the federal level that I understand was put in there, but again, our friends in Washington don't always get along. But who knows, right? It could be coming down the pike. But as we sit here today, if you do a Chat GBT search and they say, "Oh, don't worry about it, it's not enforceable," that's not accurate. We're telling people today that in Michigan, as long as it hits that rule of reason, then they are enforceable unless they hit those factors. And Tony, you can say practically, we know this. What judge you get does make a difference in enforcing, isn't that?
Oh,
I
yeah.
mean, your
Oh,
understanding?
absolutely. And, I think we'll get to it in a second, but, a lot of times what happens in these cases is if it's really serious and someone's stealing customers and they're stealing your employees and they're out there, we'll get calls from clients all the time that say they are ruining our business and we have to stop them now. And so what you typically do is you file a temporary restraining order and you seek an injunction asking the court to enter an order saying either that person will stop working for a competitor or they in order saying they will not solicit our employees, they will not solicit our customers anymore. And judges, they're skeptical. You really got to have the facts on your side to show, this person is ruining and will ruin our business. You got to be able to show that they're either taking your confidential information, they're taking your trade secrets. So again, it really depends on what judge you have. Cliff and I have had judges that say, absolutely not, get out of here. I haven't granted one of these in 20 years. And then other judges will look at him and say, well, here's a contract. You breached the contract. Here you go. So it kind of depends. And there is a sort of equitable element to it as well. For example, I think courts will look at, are you preventing someone from earning a livable wage? Is it a rank and file employee or is it an executive? Is it someone who's worked in that industry for 30 years and this is all they know and now you're preventing them from working in that industry? Or, is someone who's bounced around a lot? So these are some of the things that the courts will take into account. And I was reading yesterday as well, courts will also look at the circumstances that someone leaves. So in most cases, an employee quits and then they go across the street the next day. But there have been some cases where a company will fire an employee and then go and try to enforce a restrictive covenant against them saying that they can't go work somewhere else. And again, kind of to the equitable things that the courts look at, a court said, nah, I don't, there's some off there that you fired them and now you're trying to enforce this against them. So the courts have some discretion. These are some of the things that they look at.
So Tony, I want to talk a little bit about it though. When you were going through this, just so everybody here understands what we're saying. One of the things you can do when you try to enforce these is to run to the courthouse and not just file a lawsuit, but you could ask a judge to say, look, I don't want you to decide the case quite yet because I know there's a process. We got to go through a court case and litigation. But things are so darn important here. We're going to lose the business. You can't undo it with money. We need you to not have the dam burst and flood the town and kill everybody in the town. We need you to put a stop to this now. That's one thing you can do, but doesn't that require a little bit more than just saying we're going to win?
Absolutely. So what you have to do when you go to the court, and because it is such an extraordinary remedy that, at the beginning of a case, you're asking the court to stop someone from working or enter an order that they can't do something. The court requires two things: success on the merits, so meaning, are you going to eventually win your breach of contract, your breach of the non-compete or the non-solicit? And you have to show irreparable harm, which means you need to show the court that money damages alone aren't going to make you whole. You have to show that, I'm going to lose goodwill, I'm going to lose reputation, I'm going to lose my trade secrets that I've spent all this time and money on developing. You're going to have to show the court that, money isn't enough. I need an order now stopping this person from doing these things. And it is a high bar. And so, like you said, Cliff, you typically run to the court and you're asking them to do this. And a lot of times it's the sort of critical point in the litigation, because if you lose and the employee is permitted to just keep working there and keep doing what they're doing throughout 2 years of litigation, the concerns might go away, or the damage might already be done. So it's a huge part of it.
So just to make sure, 'cause, we could sit here for hours, honestly, and talk about this, which you and I have done on a number of cases. But strategically, sometimes you don't go to the judge and ask to stop it right away because you're not going to meet that bar. There's going to be the ability to get the money at the back end. So you could lose an injunction, still win the case. We can draft agreements in ways that help us, that make sure that it's clear on what we're going to get and how we're going to get this as far as damages and things of that nature. But yeah, it's a process, right? We draft them the right way. We look at the market conditions. We understand there are rules, there are defenses. So whether you're trying to enforce or not enforce, we look at the things you just talked about. But at the end of the day, I remember there was a show called The Office, and the boss came in one time and he yelled in front of the office, "I declare bankruptcy." But that's not how you do it, right? Same thing with drafting an agreement. You can't just simply say, "Hey, everybody, you can't compete, and you can't solicit our people." You got to do something. You got to put it in writing. And so, Rob, just to kind of finish up this topic, what's the best way to draft agreements for enforceability? What are some things we can look at?
Sure. So number one, we have to acknowledge that what's enforceable on day one may not be enforceable 5 years into the growth of your company, right? So understand this is not a check mark one and done and is a universally acceptable issue, right? I mean, you can set some standards and things like that, right? But if you have a legitimate business concern, you really do want to tailor to the extent you can those agreements, right? What may be a legitimate duration or a legitimate area for person A may not be for person B, right? So, again, when you're negotiating, things like salary, things like compensation, those sorts of things that vary, you should also keep in the back of your mind, the restrictive covenants that you're going to be asking, because we may want to alter those, right? So again, reviewing that on a case-by-case basis for, the enforceability items Tony brought up. Two is, as the company evolves, do there need to be changes, right? Three, when the company engages in certain transactions, do we need to reevaluate those? And that may also, come naturally, right? So those are those are some things you want to think about as far as timing, right? But if we're talking about provisions and actual drafting for enforceability, right? Some things that you want to have is, the blue line or blue pencil language that Tony was talking about. Yes, is there a statute that allows the court to do it? Yes, MCL 455-744 allows the court to always modify the contract, right? But having language that says, if the scope or the duration or the area, whatever factor is unreasonable, parties agree that the court may modify it to the largest possible duration, is certainly a good arrow to have in the quiver, right? If there's a challenge in the future, right? Documenting how you came up with the reasonable scope and durations, right? If you're trying to use a nationwide area for the non-competition agreement, being able to document within the four corners of that agreement why we've selected that area, right? So that way you don't have to show that extrinsic evidence in order to justify it, right? And then also just making sure you have good language, right? We've seen this before time and time again. You have non-competition agreements that are just, off the shelf, one paragraph with one sentence in it saying you're not going to compete, within 500 miles of us. Well, what does that mean, right? You're not going to compete in one areas, right? Tightening up that language and having that bespoke provision is certainly something that will help with drafting. And Cliff, as you said, I mean, we can talk about these things for the next 6 hours. Unfortunately, we don't have enough time to do that. But again, focusing on making sure that those elements that Tony was talking about was met is your best bet in drafting.
Okay. Well, hey, I appreciate it. Thanks a lot, guys. A lot of information.
Sure.
If you have any questions, I ask everybody just to reach out to us, let us know, because it's not a cookie cutter situation. There's opportunities whenever you hire, whenever you have mergers, you have sales, you have acquisitions, you're redoing your handbooks, you're looking at policies. It's a Wednesday, whatever. There's always opportunities to update your agreements, and you should. So thanks a lot. Appreciate it. We're going to move on to another topic now, one that we've gotten a lot of questions on. I'm going to asked Courtney Grusa and McKenna Rivers on this one. They are experts in this area. They've taken so much time to look at this. It's unbelievable how much can go. We could sit here probably all day long and talk about how to properly classify employees and independent contractors. And I say that because our friends in the federal government seem to not understand themselves what the rules are. They keep arguing with themselves. The same person in the same seat and title will change from year to year. And different agencies have different views of what this is. And that puts us in the middle as employers. What the heck are we supposed to do? And how do we address it? Some of this is pretty simple. Some of it is gray. And some of it is, you got to understand what the industry is and what's going on. And we segue from talking about these non-competes. And I will tell you that non-compete agreements against an independent contractor could put you in a position of a problem that you didn't even know existed. It could be enforceable. You could draft it right and all that. But if you get the person wrong, if you don't know who's your employee and who's your contractor, you have a problem. And the question is, who's your boss, right? And so I want to talk a little bit about this. First, McKenna, if you could, tell us a little bit about what is an independent contractor versus an employee. And I think a lot of times people always say, well, that's an independent contractor employee, or that's an independent employee. Those don't seem to be the right terms mixed together, but can you tell us a little bit about that?
Yeah. Well, good morning, Cliff. Yeah, I think you hit the nail on the head. There's a lot of people who kind of misidentify employees here. Really want to back up. An independent contractor and an employee are both workers who are hired to perform some specific task or to fill a role. The difference is, and really what the core of the distinction here is the relationship of that worker to the employer. So on one end, you have an employee who has a very close relationship to the employer. And on the other, you have an independent contractor who has more of an arm's length relationship. And you might be familiar with the phrase, if it walks like a duck and quacks like a duck, it's probably a duck. it's very similar here. A lot of employers, they say, well, I have a 1099, or the employee has a contract, so they're an independent contractor. But the law looks beyond that to identify who's an independent contractor versus employee, and says that regardless of if you have a 1099 or they have a contract, if they act like an independent contractor, they likely are one. And we'll go into the details a little bit more on that later.
Yeah, so the question I get a lot of times is, well, they wanted to be an independent contractor, right? That's what they wanted. They wanted to get paid this way. It's okay. We all agreed. By the way, this is what everybody does. So everybody, all my competitors are doing this, so it's okay. But what you're saying, it sounds like, is not so fast. You got to look at what they do and what that relationship is, right? Isn't that what the goal is? And so to that, what are the advantages? And a lot of people say, okay, what is an independent contractor? What's an employee? But what are the advantages of both? Can you tell us if is there something that we're missing sometimes when we just say, well, we'll just make him an independent contractor? But why? What's the point?
It's any secret that when you become an employer and start taking on employees, it comes with a lot more work. You have to manage that employee, set their hours. There's certain tax deductions that you have to make from their paychecks. Getting in later, what we're going to talk about, ESTA, maybe tracking their hours and giving them sick time, also opens up the employer to liabilities for certain employee protections they have. So I think one of the advantages of having an independent contractor is that arm's length relationship. It not only creates a little bit of protection from certain liabilities to some extent, but it also takes away some of the added work that comes with managing employees and going through all of those steps. And I think that's where we come into a lot of these issues. I see a lot with small employers when they want to make the jump from being owned and operated by just a few people to taking on employees. They say, oh, well, I'm just going to 1099, or I'm just going to give them contracts, or we're going to call them independent contractors so that I don't have to deal with it, because the amount of time and energy that goes into managing employees is just too much.
Right. Okay. Well, that makes a lot of sense. There's an ease factor. There's some other issues. Of course, one thing that people don't understand, though, is that you might lose a little control. And Courtney, that's something that sometimes people want a little bit of both ends, right? They want to both have this opportunity to not pay taxes, to just go out there, not have these added additional burdens and obligations under the law, but they also want to tell people what to do. And so can you just today, as of today, tell us a little about what are the rules? How do we know when a person is an independent contractor or not? Because I know that this has been shifting tremendously. If we were to sit here last year at this time, we were looking at something coming down that was a rule that was supposed to be in place, but I'm not sure that's in place right now. What's going on?
Yeah, so I'm definitely going to touch on that. So just from a general perspective, when you're analyzing whether a worker is an employee or an independent contractor under the Fair Labor Standards Act, there are several tests you're supposed to look at, right? The two most common ones are the ABC test, which some of you have probably already heard of, and then there's the economic realities test. For purposes of this conversation and then the final rule you're mentioning, we're just going to focus on the economic realities test, because that's the one predominantly relied upon here in Michigan. And the ABC test hasn't actually been adopted by the U.S. Department of Labor. So the economic realities test, this is the one that's been going through a lot of peaks and valleys over the past year. It looks at multiple factors to see whether a worker is economically dependent on a potential employer for their livelihood. So that's like a very fancy way of saying, we got to figure out whether or not there's an employment relationship that actually exists, right? So before I dive into those factors, I'm going to go back to some of those peaks and valleys we talked about. So in January of last year, January 2024, the Department of Labor published a final rule that essentially revised the standards that are under the economic reality test. The goal was to align them with the Fair Labor Standards Act as it's been interpreted over the years through the court system, right? They're looking at judicial precedents. So they announced that they're going to change the economic reality test. They published the rule and it went into effect March 11th, 2024. Well, with any change comes growing pains, right? And immediately employers were upset because they didn't like how the standards were in place. It was too broad. Suddenly it put people in a position where they could look outside of the scope of the factors that were in place, and lawsuits, right? Lawsuits happen. So there's a lot of legal action pending in the federal courts right now. That's caused a whirlwind as a result of all that litigation. And Cliff, you've been monitoring this too, I know, so feel free to chime in. The Department of Labor, as of May 1st of this year, issued a field bulletin indicating that they're no longer going to be enforcing the final rule, right? So they're not going to be enforcing it. It doesn't make it go away. They're just not going to be enforcing it. And I'll get into a caveat about that in a little bit. So instead, in the interim, while they're kind of working through the growing pains, they have decided to reinforce what they've called fact sheet number 13, which is from July of 2008. So we're taking it way back in terms of the economic reality test application, right? July 2008 is the new standard. If you look at that, it has similar factors to what was included in the final rule. It's not a perfect overlap, but there's 7 criteria. I don't think we need to go through all of them today, unless you guys love hearing me talk, and then I'll be happy to dive into it.
Like I said, we could go all day on the analysis, but I think that the key to everyone wants to hear about is that what are some of the key things that we need to know about if we're at risk, right? I mean, there's a lot of factors of the test, but the test, as if we sit here today, do we know what it is and what are the general factors of that?
Well, if we're relying on fact sheet number 13, like I said, it's a 7 non-exclusive factor test that you have to look at. And some of the factors look at, the permanency of the relationship, right? So are you doing sporadic work for this employer or this principal business? Or are you providing fixed work during fixed work periods? What's the nature and degree of control by the principal business? So basically, do they have say-so over your hiring practices, your firing practices, your scheduling, pay rate, establishment, things like that? Opportunities for profit or loss from the worker's perspective. So those kinds of big picture items. There's also even a factor, excuse me, for like the skill and initiative required by the worker as provided to the principal. So they're pretty solid factors. But I just want to go back because I do think it's important. While the DOL is instructing us to use this fact sheet number 13 as our, 7 factors, they will, or they have reserved for themselves the option to enforce the final rule if the circumstances permit it. So it puts us kind of in a limbo in terms of what could happen if things progress. So we're going to continue to monitor that pretty closely in the interim.
Courtney, you're saying to everybody that the federal government passed a law, went through a full fact-finding, months-long process to enact a brand new law. Part of that rule that they enacted would say things such as this. If you're an owner-operator of a truck, there's a hard time that you're going to be able to make that to say that you're actually an independent contractor. I mean, there are rules in here about even if your contract says that you could express some sort of control over somebody, but you've never done it in 25 years, that could be an indication that you actually are an employer. I mean, this was a fundamental change in the rule that you're saying is now not being enforced, but actually might be enforced.
Yeah. Talk about confusing.
I mean, it's a massive change. And so that everybody understands, under this rule, they went down all the different qualifications. And one of those that they looked at was, what is it that you actually are doing? Is it a big part? Is it an integral part of your business? So, for instance, if I have a business that makes parts and you come in and you help me make the part, that could be an integral part of your business. Now, it's not the only way that you become an independent contractor, but that's against you as opposed to something else. Now, that would be a big deal. So you couldn't just have an independent contractor that comes in on the side. It's a bigger issue. There are things that would look at the profit and loss. They will look at, are you actually engaging? What's your qualifications? All those things. to a certain degree, everything's the same. It's just it was actually more specific. We don't know. But then there's other agencies. You talk about the Fair Labor Standards Act. That's for people wanting to know whether or not they should classify a person as an employee for overtime. But
Mhm.
the question would be, or in other wages, and how about unemployment? But they have something called an IRS 20-factor test. That's a little bit different
Yep.
because under the FLSA and the DOL, they don't necessarily look at whether you have an employment agreement. I think McKenna hit it on the head when she said if it walks like a duck and it talks like a duck, it's probably a duck. But the unemployment office might look at, well, you don't have an employment agreement. You don't look like you have a website, so you're holding yourself out for business. It looks like you're dependent upon this one employer. So we're going to look at these 20 factors, and the IRS doesn't even use that IRS test. They use a different test.
Exactly.
And then I understand the AG's office, the Attorney General's office, has a special division looking at wage theft, including whether you're not paying people properly by classifying them as independent contractor. And they'll look at it, even though there's all these questions in the air about which rule to do. So I think at the end of the day, we have rules. There's a general rule that's the most probably specific. If you're good by the one that was passed, you're good by probably all of them. We have the relaxed 2008 rule that's being applied, and then the courts could do what they want to do, right? Because the courts have historically looked at it, and that's what the rule is. But control, independence, are you truly, and we need to take a look at this we can't just say we've done it in the past this way, so it's okay, is what you're trying to say, is we've got to
Absolutely.
evaluate.
Yep.
It's very sophisticated analysis, not a really easy button that we push, right?
Not at all. It's not easy at all. You have to really do a deep dive into your policies and your practices and the relationship with that person and make an assessment accordingly. You can't just put a blanket on it and say, yep, you're an independent contractor. Yep, you're an employee. There's a lot of steps to it.
Job titles aren't going to make the decision, right? Having a contract where the person says, I agree, I'm not. All right. Enforcing non-compete agreements against an independent contractor. In the new rules that were passed, it said if you require the person to do anything more than the law requires you to do, even one step more, that could be an indication that you're exerting too much control. Here's my handbook, independent contractor. Those are the rules that I want you to apply. You might have some problems, right? So it's very sophisticated. We help people out with this all the time. We go through these, it's analysis. But why will we do that? What's the use of doing all this? What's the risk? Let's say you get it wrong. What's really the problem if you misclassify somebody?
I would say most misclassifications are innocent, right? I don't think people intentionally try to misclassify, although obviously, like McKenna was saying, there's a lot of advantages for an employer to classify somebody as an independent contractor. I think for the most part, though, people really do try to get it right. But there are risks. So if somebody determines that they've been misclassified as an independent contractor, but they're actually an employee, they could have or try to bring criminal and civil liability claims against you. Fair Labor Standards Act, like you mentioned, Internal Revenue Code violations are a potential risk there. They could basically argue they've been denied certain protections that are due to them, like minimum wage, overtime payment over the years, unemployment insurance, workers' comp, say they were injured while they were working as an independent contractor, but in reality, they were an employee. So here they are paying something out of pocket when really it should have been covered by the employer. So you really want to tread carefully. If you're not sure where somebody falls, you really should consult legal counsel on this, because it's better to get it right, or it's better to get it wrong and admit that there's risk and assess it and nip it in the bud early and fix it. So
my understanding, and correct me if I'm wrong though, is that if you tell somebody that they're an independent contractor, but in fact they should have been classified as an employee, there's a chance that from just a money damages situation, that person worked a lot of hours.
oh, absolutely.
And we, as an employer, always have the duty to keep accurate records of time. So if that happens, we could be in trouble because we could have to pay them overtime.
Absolutely. Yeah.
And when you have an overtime claim, my understanding is that the person can claim, or the Department of Labor on their behalf, or all of your independent contractors together, even if they didn't even know about this, has one person says, hey, all of us are going to be in a collective action against you for the last 2, maybe 3 years, saying
Mhm.
all are owed 100 hours a week in overtime. Prove us wrong.
Yeah,
And we want double damages. And my attorney, my poor hungry plaintiff's attorney, needs his attorney's fees, which is worth even more. So we could get to hundreds of thousands or millions of dollars real quick because of unpaid time. Then our friends at the IRS might come down, the unemployment office might come down and say, hey, you owe us a lot of money for all these people you didn't pay on. And let's dig a little deeper in
exactly.
your books while we're here and find something else. And the Attorney General's office just might say, you are tax cheats. You're not paying your taxes. Why not? And so there's some big time potential damages that could happen. So it's worth the investment to look at it. It's also worth it for our politician friends to kind of get on top of this and tell us what the rules are. I mean, if we're going to be held to this, end the business kind of money, because it is. I mean, litigation on this could end your business. It could,
Yeah,
you're a public
absolutely.
employer, it could end your program, right? These are major potential penalties that are out there. And we're not trying to say this to scare people. It's just the reality of life.
Yeah.
That's the nature of the business. So yeah, so lots of risks there. It sounds like we've got some pretty standard good rules, even though they keep changing a little bit of the standards, but the standards
Mhm.
are basically the same. The control, what you're doing, how you're at, we have to look at those things. And you can't just say it. You got to
Yeah.
actually do it. You got to
You
walk
got to
it.
walk the walk. Yep.
So McKenna, just to kind of finish this topic up, what do we need to do? What do employers need to do to reduce their risk of misclassification?
I think it's kind of two-part. One, knowing that there's such a high degree of risk, I think it would serve employers well to go through and identify anybody that they currently have as independent contractors and do an initial kind of audit to see, are there potentially issues here of misidentification, misclassification of these people? Get with HR, get with legal counsel, and go through and see if they shouldn't be properly classified as an employee. And the second phase is taking on new employees. Really, before you make the decision, if somebody comes forward and says, I would prefer to be an independent contractor, you really need to look through the title, and just because they said they wanted to be one, and look at the core function of what they're going to be doing, how they fit into the business, and what degree of control are you going to have over that person to decide whether it's even appropriate to have them be an independent contractor. And then again, reach out to legal counsel to have them help you identify who should and shouldn't be, and whether a certain position can be properly labeled an independent contractor.
Yeah, great advice. You know, it kind of goes back again. A lot of these laws have very similar concepts. When we were talking with Tony and Rob, one of the things that you look at is enforcement of non-competes. Is it consistent across the board? That could be a defense. If this is so important, well, why the heck didn't you enforce this on Johnny and Susie, but now all of a sudden you're coming after me? The same thing sort of comes into play here. You don't want to have employee A be an employee and then independent contractor B doing almost the same thing with the same rules, the same restrictions, the same everything, but you're classifying them differently. That's probably a telltale sign that you might have a problem, right? And so audit yourself, take a look at what you're doing, how much control are these people dependent on you? What are they doing? That's just, I mean, these are just great things to think about to make sure you're on the right side of a potential powder keg, frankly. So yeah, I really appreciate it. Thank you, Courtney and McKenna. Great information. And if anybody has any questions, obviously follow up with them. And I think they're a great resource here at the firm. And I enjoy talking to them because they have a lot of knowledge and information on this. So just moving along, you know, we've got a lot of topics, and I know it's a lot of information that we're throwing at everybody here. Courtney's going to stick around here though, because her and Tony want to talk a little bit about something that probably everybody's looking at. What the heck's going on in 2025? I thought we had a lot going on in the last two, but no, wait, there's more. There's even more shifting legal landscapes. There's a lot of different topics that are hitting, because whenever you have a change in administration from the federal government, people vote, there are results. Okay. And at the federal level, we used to see things happen slowly, right? You'd have an election and then they'd say, I'm going to do this, that, and the other. And then, 3 years later, they do half of it, right? Imagine a road construction issue, right? That's just something I'm throwing out there, right? But, you wait a couple years and all of a sudden you notice the orange barrels are up everywhere. Not so fast now, though. Actually, really fast now. What we're seeing in the last two administrations has been almost warp speed as far as I get in and I'm making changes. I want to ask a little bit, Tony, on the topic of discrimination. Okay, we have a lot of employers here. Can you tell us if there's been any major changes out there in the last year that our participants here on this webinar need to know about? Because I think there's been some significant things people might not have been tracking yet.
Yeah, absolutely. And so I think on this topic, we're going to talk all things discrimination. And so, as you know, there's a lot of anti-discrimination laws, both at the state and the federal level. And generally, these laws prohibit you from treating employees differently based on a protected characteristic, such as race, gender, disability, etc. So what we're looking at, there's a couple big updates and things that we're watching right now. First is the federal government's focus. And so Courtney and Cliff will talk a little bit later about DEI, but we've had a lot of executive orders this year. And as Cliff mentioned, things are moving at rapid pace. And one of those executive orders back in April told agencies to deprioritize disparate impact discrimination claims and put resources towards intentional discrimination claims. And so what the EEOC did is they came out publicly and said, hey, yep, we intend to comply with any and all executive orders, and we will prioritize remedying intentional discrimination. And so when I say disparate impact claims, what I mean is a situation where you have a neutral employment policy that has an unequal outcome of employees of a particular, usually race or sex. So what this means is that the EEOC's focus is not going to be on disparate impact claims, it's going to be on disparate treatment claims or intentional discrimination claims, which means that typically an employer is treating someone differently based on their race, their sex, or a protected characteristic. So this is something to keep in mind for the next probably 3 years on where the EEOC is putting its focus. And on that point, the second big thing that we're watching is religious accommodations. So a couple years ago, the Supreme Court raised the bar for denying a religious accommodation, which we'll talk about in a little bit. But the EEOC came out just 3 weeks ago, and they put a presser out there saying 200 days of EEOC action to protect religious freedom at work. And they've came out and they said that they are prioritizing making sure that people don't have to choose between their paycheck and their faith. And their position is that, religious protections have taken a back seat, and they are all in on enforcing and charging and coming after religious discrimination claims. So those are the two things on sort of the federal government's focus. On the case law side, we had another big Supreme Court case just this summer that changed the Sixth Circuit's background circumstances rule in what's called reverse discrimination cases. So now everyone uses the same Title VII framework, which I'm sure we'll get into a little bit. And then the last thing is a Michigan Supreme Court case, not a federal case, that looks at and scrutinizes those 180-day limitations you put in your handbook and whether or not those are able to be enforceable. So, lots of things we're looking at right now. That's kind of a broad overview.
Okay, excellent. I did want to raise one thing, literally raise. There's a program called RAISE. It was around for years and then was discontinued under the Biden administration and recently brought back in. Then we were talking a little bit about misclassification, but there's lots more reasons why you didn't pay somebody overtime. You forgot. You didn't know that you had to add a bonus into the overtime calculation, right? There's things that can happen where you go, uh-oh, we made a mistake. We misclassified the person. We just forgot to do this right. We didn't calculate it, or a payroll program. There's a million reasons why you can innocently not pay somebody overtime. It used to be you're in trouble because the only way you could settle, the only way you still really can settle a claim is if a judge tells you, there you go, you settled it properly. Well, nobody wants to get in front of a judge. That means you've been sued. Or the Department of Labor says it's okay. You only get there generally if someone brings a claim against you, or you voluntarily do that. But this new raise program is something you can voluntarily do. You can go to the Department of Labor, you can ask to be part of it. This is new. It's something to help people, because a lot of times people say, well, what do I do? I mean, if I go tell everybody they're entitled to overtime, they might sue me and get double damages and attorney's fees, and then they don't sleep at night and they're afraid that somebody's going to get sued, maybe them. So what this does is say, hey, look, come to us. We'll help you out. We'll take a look. You do an audit of yourself. You bring it to our attention. You should be good. But you can't have been part of an ongoing suit or a Department of Labor program. You can't have been part of this issue. You can't have, in the last 3 years, a Department of Labor finding or a wage and hour claim against you before you do it. Pretty big change, right? Pretty significant. So we hear all the things that Tony's talking about, which again, very significant changes in discrimination law, especially we'll talk a little bit more, I think, in detail on the religious discrimination in a little bit, which I think is big, but all the discrimination cases, even potentially the way that we look at it. So a lot of stuff. But Tony, you talked a little bit about religious accommodation, but can you tell me how it shifted? Like, what are they actually doing? My understanding it's pretty significant change, my understanding.
Yes, so the Supreme Court in 2023 in Groff versus DeJoy, in that case, Mr. Groff was a postal worker and he asked not to come into work on Sundays for religious reasons. And the lower court said, the lower court used to say, if an accommodation caused more than a de minimis cost, basically, anything more than that low bar, you could deny it. Well, the Supreme Court in Groff clarified that showing more than a de minimis cost, that's not really sufficient. That's not what undue hardship is under Title VII. So instead, the Supreme Court said, no. Undue hardship is shown when a burden is substantial in the overall context of the employer's business. So now what we're looking at is the nature. We're looking at the size of the business, the operating cost of the business, and you really need to, and Cliff and I will talk about it a little bit later in the program, but you're going to have to document and be able to show, financially what undue hardship looks like if you deny a request for a religious accommodation. So this is a huge jump from the old sort of more than de minimis standard where any sort of small cost you'd be able to say no. So what that means is that coworker complaints, if you deny a religious accommodation because other employees won't like it, that's not enough. If you don't think your customers will like it, that's not enough. You got to try schedule changes. You got to try temporary reassignments. And if you deny it, again, you better be able to actually substantiate the undue hardship there. So if someone comes to you and says, if you run a restaurant and says, I don't want to work on Saturdays, I have, a sincerely held religious belief, you're going to have to engage in that interactive process, try to schedule their shifts, swap shifts. And if you say, well, everyone will be mad, you're going to be in trouble. And so, again, that's kind of where we're at now in terms of the standard. And now we've got this press release by the EEOC that says 200 days of EEOC action for religious freedom. So they are prioritizing coming after religious claims. They're touting the more than 10,000 religious accommodation charges they've received since the Biden administration. So they're focusing on this now. This is a big deal. So what we want you to do is keep your ears up and make sure that you train your employees. You're listening. If someone emails or tells you, hey, I've got a your dress code policy conflicts with my sincerely held religious beliefs, or I don't want to work on Saturdays, you cannot just deny it. You're going to have to engage and talk to the employees. So it's a big deal. You cannot just deny it now, or you could get hit with an EEOC charge because, again, they're coming after these cases. You could have a lawsuit. There's damages. There's back pay. It's not good. So just, we want to emphasize being careful here.
Yeah, we'll probably touch on this a little bit later too on the religious, but can you give me a couple examples of how the EEOC is really some cases, for instance, that you've seen?
Yeah, and there's a couple types. So the EEOC is there's religious accommodation cases related to COVID-19 exemptions. So these usually involve healthcare providers, hospitals. So they've published $1 million settlement against Mercy Health related to a vaccine mandate. The Mayo Clinic they've come after. And then there's other cases, sort of standard, quote unquote, standard religious discrimination cases where it's related to dress, it's related to Saturday or Sundays off, or requesting time off for the Sabbath. So, specific examples, and Cliff and I were talking about it yesterday. P.F. Chang's 2 days ago, they got hit with, they were required to pay $80,000 for religious discrimination when they didn't hire someone because of their request to take Sundays off. Buffalo Wild Wings. 3 weeks ago, they were ordered to pay $47,500 because a candidate were requested to wear long skirts, and one of the managers said, "Yeah, our servers don't typically wear long skirts." The Venetian Las Vegas had to pay almost $1 million for refusing to accommodate sincerely held religious beliefs. A staffing company called Logic Staffing failed to hire a Muslim job applicant because he asked for religious accommodation to attend Friday prayer. The Marriott, the EOC sued because a sales executive requested to observe the Sabbath in accordance with her faith. A dental clinic ordered to pay $61,000 for firing an employee over her request to wear a scrub skirt instead of typical scrubs. So these are all real cases, literally in the last couple months. So the EEOC is coming after these cases. They're taking it seriously, and it can be really expensive if you don't pay attention.
Tony, it's interesting. I remember there was a jury verdict not too long ago here in Michigan on one of the COVID vaccine issues, a sincerely held religious belief case. And the jury hit, I believe, for over $12 million. And so it's real, it's happening here, and it's happening now. But this predates the whole idea of the religious accommodation. It's not just something that came out of the COVID-19. I think sometimes we get a little fixated on the issue of, well, it's about vaccines. It's not about vaccines. It's more than that. And what the Supreme Court has done, it sounds like, is, and employers need to understand this, I need Sundays off because I go to church and I think that's a sincerely held religious belief. What you should not do is you shouldn't get them into deposition and say, okay, here's the 10 commandments. Which one have you broken? And so, so you're not a real Christian. So you go to church, but you pick and choose. That's not going to go over well when you go into court. There's more to this. If a person has a sincerely held belief, the next question is, does that belief pose an undue hardship? And I don't want to get into it because we're going to go a little bit more, but there's real money at stake, and it's not what it used to be. And it's sometimes people say, well, your religious belief isn't as important as a disability discrimination case. And the Supreme Court, United States Supreme Court, has said, not so fast. That's not the way it should be. We got it wrong before, and that's where we're at now. That's shifted. That's a seismic shift. Going to the Friday prayers, the one that was out in Seattle you talked about, sizable, and we'll talk about a little bit more. It's not just a $20,000 or a $10,000 hit, a big time hit, because the person didn't just say, hey, I'm going to be off on Friday. They said, hey, can I have some extra time off to go to pray? And you know what? If I can find a mosque nearby, don't worry about it. I'll just go there and I won't need the accommodation. And they said, yeah, we don't need to hire you. Well, you got hit with a lot of money. We have to train our managers, our hiring professionals, not to just simply scoff at religious accommodations, because it can get you really quick with a big penalty. So, okay, now let's talk a little bit about here. There's a big Supreme Court case about reverse race discrimination, and I think people need to hear about this. This is new. It changed the law. And I think individual employers sometimes don't understand how the whole race discrimination process works in the first place. But this did change it. Can you explain a little bit about that one? Because I think this is going to be significant for employers to make sure they're doing the right thing when they make decisions on hiring and firing.
Yeah, absolutely. So Ames, which is a very recent Supreme Court case, ruled unanimously, which is unique, to reject the Sixth Circuit, which Michigan is in, their background circumstances sort of rule. So plaintiffs who are in a so-called majority group, they're not typically what you considered a minority. And so what happened in this case is a heterosexual woman was denied a promotion and she was subsequently demoted while a younger gay man stepped into her former position. And before her demotion, a gay woman took over the promotional role. So she filed a discrimination complaint with the EEOC and then sued under Title VII, alleging discrimination based on sexual orientation and sex. And at that time, because she was what courts in the Sixth Circuit would consider a majority group as a heterosexual woman, the Sixth Circuit applied something called the background circumstances rule, which required her to show that the employer who's allegedly discriminating against her was the type of employer who unusually discriminates against majority groups. So this was kind of a higher bar in these so-called reverse discrimination cases. And the Supreme Court struck that down unanimously, and they made clear that plaintiffs must all be treated alike and that Title VII protects any individual from discrimination based on sex or sexual orientation, regardless if you're in a minority or a majority status. So I think there's some misconceptions about what this case actually said. So now Title VII, it treats everyone the same, regardless of whether you're in a minority or you're in a majority group. So for your hiring professionals, for your managers, if you get hit with a sort of sex discrimination claim or any Title VII discrimination claim, there's now not a higher bar to hit for so-called majority group plaintiffs. So it sort of evens the field there, and frankly, there's a little bit more litigation risk because it's less of a burden for plaintiffs to show now. So big update for Michigan employers.
So put differently, the old adage of, well, is anybody here in a protected class? The answer is always yes.
Correct.
Always yes, right? That's what I think is the biggest takeaway here is everybody's protected. I can't tell the audience here clear that if you take one thing from today's seminar, it is what has significantly changed in 2025 is a loud and clear message from the federal agencies, the United States Supreme Court, and the federal government as a whole, that you may not discriminate against people under the law, period. So all the things we've always done as far as EEO policies, as far as non-discrimination policies, none of them have to change. None of them have to change. You don't have to do a thing, but you do have to apply them. And you have to apply them so that no one, doesn't matter if they're a white female, if they're an African-American male, if they're an Asian American non-binary person, it doesn't matter. What we have to do is we have to ensure that we don't discriminate based on a protected classification, which is race, sex, age, and all those other things that we have under the law that we've always had under the law. So I think that's the takeaway is this law took away the requirement that you have to be that special kind of employer that discriminates against majority people. That factors out of it. So a big deal, I think internally, it's a big deal just to make sure people understand that. So when they do hiring, layoffs, we'll get to all these things later, firings, terminations, just make sure that what you're doing is a legitimate business reason, period. There you go. I understand as far as the shifting change as well that I wanted to talk about a little bit is the EEOC taking out this concept, and we'll probably talk a little bit more, this concept that they've had historically that when you go into a discrimination case, they look at the impact, right? They say, has this non-discriminatory purpose decision, we decided to do something, we didn't really want to do it for any real discriminatory reason, and you can't prove that we did, but does it have a discriminatory impact on a certain race or a certain gender? Now, if you do that, then what they call that was a disparate impact case. So you could try to prove a claim saying, well, maybe they didn't think it was going to impact us, but it did. And the EEOC has just come out and said this year, forget about it. We're not doing that anymore. We're not looking at the impact. We're looking at what you were doing. So not only did they take the bar off to say everybody's now covered, they've also said, oh yeah, but on the other side of it, we are looking at why you did what you did. That doesn't mean the courts won't continue to look at disparate impact and that people won't sue you. I'm not saying you shouldn't look at that, but that is a significant change from the EEOC. So the federal government agency in charge of looking at what you're doing wrong seems to be looking at, are you discriminating against people because of their religion? Don't put a lower bar. Are you discriminating against people because they fit into a classification? Don't worry about what classification. And more importantly, when I say discrimination, what is it that you're doing and why is important, not necessarily the impact. Not and Courtney and I will talk a little bit more about the equity concept and how that fits in there. So those are pretty sizable changes that employers are going to have to not change their rules necessarily, but change the way they manage. So Courtney, going to you, I think recently there's also been a Supreme Court case, Rayford. And can you tell us a little bit about what happened in Rayford? Is that a pretty big deal?
Yeah, so excuse me, Rayford versus American House Roseville. That's a Michigan Supreme Court case that just came down. And this case addresses that pesky 180-day lawsuit deadline that Tony mentioned earlier. The facts of this case basically involve a nursing home employee who signed a handbook acknowledgement a week after she began working with her employer. The acknowledgement included that limitation period, that 180-day cap on when she could bring any lawsuits or claims arising out of her employment. Unfortunately, several months after she started working for the employer, she was terminated. And then about roughly 3 years, not quite 3 years after the fact, that same employee filed a complaint alleging that the employer or that nursing home violated the Elliott Larson Civil Rights Act. And in her claim, she said that there was harassment, there was retaliation, that she was working in a hostile work environment, and that there was discriminatory acts against her. The nursing home immediately argued, well, this wasn't timely. You failed to file your lawsuit within that 180-day limited deadline period. And, as a result, basically you're barred from bringing this claim. The case, obviously, like I said, progressed. It went all the way to the Michigan Supreme Court, and they found that these clauses aren't necessarily void, but they are also not automatically enforceable anymore. You can't just presume that they're valid just because they exist and somebody signed off on it, right? A lot of times, especially like in the handbook situation, which I think a lot of us in our practice group have seen, it's boilerplate language. But the courts are now applying what they're calling the reasonableness test or review to make sure whether or not the inclusion of that clause actually makes sense. Is it reasonable? And they're giving it extra scrutiny when there's evidence that that clause wasn't negotiated over. In this fact pattern, for example, the employee didn't sign it until a week after. There was no negotiations. It was just, hey, you already started here. You've already, accepted your employment. We just need you to sign this document. She didn't have any say, so she probably didn't look very closely at that clause. And that's a situation where the reasonableness review would really factor in nicely. So, for example, if someone were to bring a discrimination claim 9 months after the incident occurred, and their handbook had that pesky 180-day clause in it or limitation, a judge might actually let it through if they think that it was unfair, or if it was hidden, or if the employee just didn't have a chance to fairly negotiate or discuss it. So to me, that's a pretty big one. And I think a lot of employers should be checking their handbooks for that, because I know quite a few who have similar language in place.
Yeah, I drafted it. I draft it all the time. This is outrageous.
You're the person.
Well, I would have written a dissent, because I put it all the time, because, when they make these laws, right? When our friends at the state level and the federal level make these laws, I think they always get it wrong when they tell people how long they have to file a lawsuit. I'd like to make the decision on how long you have. I know it says 2 years, but let's make it 180 days. That's awful nice, right? I thought it was great that us attorneys could do that. And finally, what the court basically said is, wait a minute, hold on a second. We wrote the laws in the legislative sector, not the employer. What are you doing? You're limiting people back. So to a certain extent, this isn't something that I can sit there and say, yeah, I'm shocked by, right? I mean, this is not something that we should all be shocked by, but it is significant because this is what it means. Remember, we've had a lot of these seminars where we talk about how long do you have to keep documents, right? How long do you keep documents? Well, the law might say you can throw it away after a year. But what if you've got a person now who's got a 3-year statute of limitations under Elliott Larson? So the day they get fired or the day they got demoted or whatever negative thing that happened, and they come back in 2 years and 11 months from now and they file their lawsuit and they remember it like it was yesterday. And you don't remember it at all. And half the people that were there are all gone and you threw those papers out the door. This is a pretty big deal. What this does now is it places on us a lot of burden. So I guess that gets to you, Courtney, just kind of to finish this up. What are some steps we can take in HR to reduce discrimination risk, but some other associated issues to think about?
Well, going back to what you said about everybody is protected now, right? Piggybacking off of some of Tony's content. I think the easiest thing, right, in this situation is to not treat somebody differently, right? Because of their protected class. That would be the easiest little caveat that you could place on this. And an employer can, never go wrong by fostering, that kind of inclusive, respectful workplace and ensuring that their employees are feeling, valued and respected and can come to management openly and discuss things, right? That's the, if the world was rainbow and sunshines, what I would recommend to reduce risk. But in reality, developing strong documented anti-discrimination policies is probably the best place to start. That's going to entail conducting regular audits with your HR professionals or your legal counsel to ensure there's no bias in them. Review your recruitment and hiring promotional practices. You want to make sure that your action is based off of neutral criteria and not on just some bias factor. This will not only help you widen your actual application pool, but it will ensure fair workplace opportunities from interested candidates. Another one is provide regular and inclusive training for your staff and your employees, especially your managers who are going to handle a lot of the day-to-day focus of these policies. Make sure that they actually understand what's expected of them, not only by the employer, but under the law. And another big one is just establish clear and accessible procedures for reporting concerns. You want employees to know where to go, what they need to include. And this goes back to your record retention comment. This is important for just record keeping to protect the employer in the long run as well. Just having these systems in place so that when or if a situation arises, nobody's caught off guard and there's a system that can be followed step by step. Those are probably the best ways of just ensuring, I can't say ensuring, but reducing potential risk.
It goes back to the old, this is the worst employee I ever had. Of course I had to fire them. And you get the personnel file and it's got one piece of paper in there. It's their application. And you're like, well, what happened? Did you write them up? Wow, we warned them all the time. Well, who warned them? I don't know. It was 3 years ago. I can't remember. Okay,
Yep.
well, there you
Happens
go.
all the time.
Now you know why you probably should, get on top of these things. So it's an interesting way to look at things that we're being forced now to be better at HR, be better at record keeping, be better at doing what we have to do to keep our records in place because we can't shorten the statute of limitations. And in many cases, those are long statutes. So it's not that it's the end all be all. The Supreme Court did not say you can't limit statute of limitations. They basically did, but they sent it back to say, okay, in this circumstance, is there a legitimate reason that you should shorten it here? In most cases, I think what I'm reading from the decision is you're not going to be able to in most occasions. Now, what we can do is look at certain people, right? Certain jobs, high-level executives, employment agreements. There might be an opportunity to do that for those people or for some people, but we can't just do it for everybody like we used to in your handbook. And I think that's great. I appreciate it. Courtney, Tony, great stuff. If you have any questions, please call them. I mean, we just think that there's a lot to talk about in developing laws, but we can't just go into everything because we literally could talk all day on that issue. But I want to turn now to another topic, and this is layoffs, reductions in staff, and some considerations that we're going to use. And it's going to segue nicely, I think, into another one, which is how to provide employment separation agreements. Which is I'm going to have my partners Carl Buter and also Rob Hammer will be chiming in on that topic here in a second, but I'm going to segue into that real quick. And Mike, I don't know if you have the ability to talk. He had a little technical issue or not. Can you hear at this time, Mike, what's going on?
Yeah, I have a workaround. We're gonna get some echoes here, I think.
Well, that's okay. Mike conveniently decided to have technical issues today. That's okay. No big deal. But we're just going to talk a little bit about, what are some things that we need to talk about when we are going into a separation, right? What are some layoff and reduction in staff considerations? And the first one I always talk about is the WARN Act. And a lot of you are just going to kind of shake your heads and say, it doesn't apply to me. I don't know enough people. So that's fine. And that's great. But if you grow and you get bigger, you might have the problem. And you know what? Sometimes businesses get big quick. Okay. And you might not know you have 100, or you might say, look, what are the general rules for WARN Act? And it's pretty simple what the WARN Act is. You got to know what it is. The general rule is, do you have 100 employees? Yes or no? Okay. If you know you have 100 employees, it's usually pretty good. And then how many people are you going to lay off? That's the general rule of thumb is if you have 100 and you're going to lay off 50, you might be in trouble here. Okay. I think that's when you get yourself into a potential situation. But counting employees is a little bit difficult because you sometimes exclude people working less than 20 hours when you count, but you have to give them notice when you have a WARN Act. And let's just say you're going to have a major layoff of production. All right. So you have a group of people that you're going to lay off. We take a look at how many people are going to be affected. If we're going to be near 50, let's go ahead and do the math. We could literally sit here on the technicalities of the WARN Act for hours and talk about it. There are some issues that come up, but for the most part, you have two types of WARN Act required layoffs. You have a mass layoff, okay, that triggers that. And that means that you have these 50 employees, okay, excluding your part-timers, working less than 20 employees. And that represents at least a third of your workforce, unless you have like 500 employees. And then you get rid of that 1/3 of the workforce rule. Okay. Now that's triggered potentially. And then you have notices. And you don't just send notices out to the employees. You've got to send it to somebody specifically designated in the state, as well as the highest political official in your local area. And if you have a union, you've even got to send it to the union rep. You got a lot of notification procedures. Now, the other way you can trigger this is a plant closing. A plant closing can happen. And that's not just, hey, we just decided to shut down a plant. It actually could be a unit within the plant in a single location. Of course, as always, statutes have all kinds of meandering rules about what's a single location. You might have thought a single location meant a building, but it doesn't. It's actually a little bit more complicated. There could be another group where people go back and forth across the street and they say, well, that's all the same thing. And in that case, again, if it's 50 employees, of course, it's 50 affected employees, which means if you're there's an example in the DOL rules. It says, oh, we decided to lay off all of our accounting department, laying them all off, 45 of them. You go, oh, we're safe. Well, wait, because of that, 5 other clerical staff are being eliminated. Uh-oh, now we've got 50. Okay. Well, now we might have a requirement to send out a notice. And the notice can't just go out the day beforehand. It's got to go out 60 days in advance. And if you don't know whether you're supposed to put that notice out or not, and you haven't looked at it 75 days ahead of time or whatever, you could have yourself a problem. Because what can happen is there's damages associated with this, and the damages are pretty significant. Everybody gets up to 60 days of pay, depending on what the notice is. If you give it late, you can still kind of offset it a little bit, but you get 60 days. You get a statutory fine, and the best of all for attorneys, you get attorney's fees from the court. So everybody, let's just say you had 100 people you laid off. Every one of them is going to get 60 days. Uh-oh, that's going to add up pretty quick. And then some attorney might go ahead and say, well, I'm going to represent all these people. I've done so much work adding all these numbers up that I'm going to get attorney's fees for this. So it can add up pretty quickly.
And what the even worse possible outcome is, instead of one attorney representing 100 people, you get 100 attorneys representing one person.
Yeah, exactly. Yeah. So you could get yourself into a world of hurt without knowing what's going to happen. And I don't want to go down into the details of the WARN, but the WARN notice is not just a, hey, by the way, we're closing down. There's actual specific information that's got to be on the notice. you need to work with counsel to make sure that the notice is, one, addressed to the right people, two, done timely, and three, has all the right information on it. If you're doing a layoff, please think about it and don't get cute, because the statute at first says, well, we're looking at a 30-day period. So in other words, I lay off on day one, and then I lay off another 10 people and another 10 people, but you add it up and you've got yourself 50. But then in another section, the preamble, it says, well, actually, we're looking back 90 days. And every time you do a layoff, it resets that calendar. So if you're laying off and you're going to hit 50 aggregate, you could get yourself in trouble. If it's part of the same reason, then you've got yourself a problem because you didn't actually give the notice. And you've got to update these notices. And let's just say it's going to get pushed back because of some circumstances. There are opportunities, depending on how long you're going to push it back, to just send a notice and say, hey, sorry about that. We were going to lay off on this date. We decided not to. And generally, they give you a 14-day window that you can give a notice for. But if it's for a longer period than, say, 60 days than what you initially said, you actually have to resend the notice out altogether as if it's a new layoff notice. And every time you don't do it properly, you've got a problem, and there could be damages in this. So we have to be careful. Don't get cute with your layoffs. Now, there are some exemptions for this too. So, for example, the exemptions would include unforeseen business circumstances that were truly unforeseen at that time. That's a legal issue. I would definitely talk to your counsel if that's what's going on. What you can't do is say, I've been watching how bad things are going. I've decided to lay some people off because things just aren't going good. The board's on me. I got to make some decisions. That's probably not going to fall into it. There are some, force majeure issues that come into this, but you have to fit into the exemptions, right? That's number one. Number two, we got to watch out for, we're going to sell the business. We're going to sell it. We're going to merge. We're going to be purchased. It's going to be an asset sale. It's going to be a non-asset sale. It's going to be business, whatever the deal is. Technically, if people are going to be fired from your business and then hired by a new business, you're under the auspices of the WARN Act. You may have to send out a notice. Or on the other hand, you might not have to, because there are some exceptions in here that are good things, which means, yes, you're being fired by company A, but good news, company B is going to hire you all off, and they're going to give you the same or similar job, same or similar wages, in the same or similar geographical area. Great news. We're probably not going to get WARN, or if only a couple people are going to be affected and not have same job, you probably aren't big enough as far as a layoff for that. Unless, of course, you try to keep it a secret and don't want to tell anybody about the sale until the last minute. Then all of a sudden you did know about it. And it turns out the seller says, well, all of your people, now that I'm looking at them, they're terrible employees. I don't want to keep them. And now what happened? Now they don't hire the people. Generally, the rule of thumb is the seller is responsible for the WARN notice, period. And unless the decision to let go happens after the sale. Now, if they decide, hey, we're going to bring you on, and they go, you're all terrible, we're laying off 100 of you or 75 people, they could have some responsibility. And I'm not going to get into this because it's probably going to be talked about with Rob and with Carl in a couple of minutes, but that's something you can talk about when you're negotiations. But the long story short is, WARN Act is important. All right, I think it's important to remember layoffs, making decisions. And there are exceptions. If you give people early retirements or they're terminated for cause unrelated to the actual layoff, they don't get added, but you can't get cute because there are real world exceptions. And the people that drafted the law knew that people would try to bring things up. So I just think that's a general 30,000 foot view of the WARN. I don't want to get too much in, but if you do have questions, I do strongly suggest you call one of us to talk about what you're doing, whether it applies or not, because it's very fact specific. Now, one of the other things I wanted to talk about a little bit was how to avoid discrimination and retaliation claims during layoffs in general. Well, this is a very big deal. I talked about the EEOC getting rid of the disparate impact for their analysis. That does not mean that it won't be used during a lawsuit by an individual and addressed by a court. And I'll tell you, one of the factors that comes into play a lot is age. When you're doing a layoff, and you want to issue an age, and I don't want to step on the toes of Rob and Carl when they talk about how to do separation agreements, age is not only a major factor in layoffs a person could bring a claim on, if you do get a sign off on a release, the nature of a release that you get when you're doing a layoff or you're offering terms, it's different than any other release that you have. You have to have special language for older workers. So it's very important. So they'll probably address some of those issues, but I won't get into it. But you got to look at, are we going to have people that are over 40? Under federal age law, 40 is the big issue. All right. Are you over 40 or under 40? According to the federal government, when you're 41 years old, you may be senile because you have 7 days to rethink whether or not you want to sign that or not. You have buyer's remorse for 7 days. If you're 39, you're crisp, smart as a tack. You just sharp as a tack. You're out there signing documents, but not 50-year-olds. They can't do it. They can't be trusted. So there are different rules based on these things. Who are we going to lay off? Are we laying off only the females? Are we laying off 10 people? 3 of them happen to be the ones that just raised a claim about, hey, it's unsafe in this place. This is not a very nice place. Are we only laying off 7 people and 6 of them just went out on FMLA? We have considerations that we need to look at when we lay people off that go to common sense. What's the impact? So we look at, why are we doing it? Do we have a rule of thumb? Does our handbook address layoffs? Do we do it based on strict seniority? Do we have a union contract? If we don't have a union contract, what do we do in our handbook? And what is our practice? When I look at how to defend a discrimination case, because this happens a lot, people get laid off, they get offered a severance, they say no, or maybe sometimes yes, and then they come back and say, I think it's because of age. I think I was included in that group of 50 people because I'm old. Or I think I was included in there because I am in any particular racial category or any particular religious category. And you have to be able to say why. And a lot of times employers say, well, look, we just put the best workers. We went around the managers. We asked them, who's the best? And they said, well, Johnny's the best. So don't lay him off, but Susie's a bum. Okay, that's great. Why is Susie a bum? Is there some articulable reason that we could put in front of the EEOC or a judge or somebody on that jury that you could walk out on the street and tell them, this is why we laid this person off? And they would go, all right, makes sense. I don't know if I would do it the same way, but at least it's a legitimate, non-discriminatory business reason. So think about those things. Considerations for rehiring and post layoffs. Again, the WARN Act only applies for long-term layoffs of 6 months or more generally, okay? But your layoff might be for less. How do you want to address it? Do you want to have a system in place where you give people a separation agreement? You're calling it a layoff, but in reality, you're firing everybody, okay? You want to articulate what the heck you're doing to people. Don't tell them, oh, you're getting laid off. Oh, okay, I'll sit by the phone and just wait. Well, you're giving people the wrong expectation. You need to let people know. Look, we hope this is a short-term layoff, but we don't know, right? That's an honest statement, okay? If you're saying to people, look, we're laying everybody off, we just don't have work, we just don't think it's going to happen, we wish you the best, but please go look for a job. We don't know. Or it could be, we don't have a clue. We will be calling you if we have a chance. And then you have an internal process. You have to think through before you do it to the extent you can. What's our process for recall? Is it going to be by department? Is it going to be by need? Is it going to be, by area? Is it going to be by seniority? Is it going to be by, we go to the managers and say, what do we need first? There's a process that should be documented to help protect you from any type of litigation. And I always say, I understand things happen fast and everybody wants to get things done. There's an operational decision and then there's a human resource decision. They don't have to be mutually exclusive, okay? They can work together most of the time to try to make sure that we have one sound reason. People need to work together. And if there is a reason to get rid of somebody that's not lawful, that reason should be eliminated. Simply put, because if you don't eliminate it, somebody will most likely find it through litigation. The other thing is, and all the attorneys on here will say, if you ever get sued, there's something called discovery, and they ask for everybody's emails and everybody's text messages and everybody's memos. And if you have one of those memos, a loose statement that looks really bad, then it might give the person a claim. even if you didn't mean it. So you have a little note on there, age, by somebody who's 72 that you laid off along with the other employees, but kept all the 20-year-olds. Guess what? You might have meant, hey, this person's great looking for their age. I don't know, but you better not put that on there. And if you write a text message saying, let's get rid of all the old guys and get some new blood in here, you're going to get sued and they're probably going to have a chance to win. Okay. Be conscious in your decisions and in your writing. So again, those are the best practices, in my opinion, of what we do when we have to consider laying off people. We have a WARN Act. It's an obligation. We have various laws about disability discrimination, age discrimination, sex, race. All those things should go into play to make sure that we're not focusing on that. And I think if we do that and we consider the process for laying off, who, what, when, where, and why, what the decision makers are, and we have the rehiring understanding of what our process is, it helps us go into the next step, which is if you want to give people separation agreements at the end, that you will have already gone through a process to get there. But I will say people get sued for retaliation and for other discriminations because they do not think through their layoffs. And that's been a consistent source of litigation that I'm seeing this year. I'm in a number of litigations and claims before different agencies right now on this very issue. So I'm speaking from just past experience, but the fact that some people just don't like being laid off and they don't want to hear what you have to say. The best way to approach this is have a system. Have a system, have it written, and if you have any questions, call your counsel so that you can talk it through. So with that, Mike, I don't know if you have anything to add with your workaround, but if not, I want to go over to Rob and I want to talk about separation agreements and how to provide them. And a lot of times they come with this layoff and reduction issue. And I want to talk a little bit about it and say, what is a separation agreement, Rob?
Sure, absolutely. And Cliff, before we get into that, I also wanted to point out, because it segues very well from your topic into our topic, there is constantly legislation that's proposed in Michigan dealing with these mass layoffs and what you may have to give people, right? For example, you have House Bill 5890 right now, which if passed, right, it's still obviously in legislation, would require certain severance benefits,
Sure.
if you have those sorts of mass layoffs that's out there. So it's something to pay attention to, because what we're going to talk about is more of the voluntary, severance agreements, right? You don't have to give people severance agreements, right? Or severance payments or bonuses unless you have, a contractual requirement to do so. But there's some legislation coming down the pipe, potentially, that may alter some of the things that we're talking about. So I do advise everyone to kind of keep their eyes open, because this is an issue that is getting a lot of attention, a lot of traction here. So turning to your question, what is a separation agreement, right? Separation agreement is just an exit contract, right? If you have an employee that you're terminating for whatever reason, whether it's one or a multitude of them, you always have the option, and they also have the option of refusing, of negotiating certain exit procedures, right? And those procedures can involve, the payment of money. They can involve, the payment of certain, ongoing expenses. It can involve, things like restrictive covenants, circling back to our first topic of the day, right? Maybe we need to plug some holes, in the documents that are there, or something has changed. And we want to make sure to protect the company, whether it's through a non-compete or a non-solicitation, right? And in order to do so, we're going to offer to pay certain amounts of money, right? So a separation agreement is really just, the agreement that parties are going to live by in order to walk away from each other. It involves, often the waiver of certain claims, the acknowledgement of certain issues, right? The requirement to turn in, all of the company property, or the acknowledgement that that company property has been turned in, right? So again, it's that standard, and I don't want to say standard form agreement, because none of them are ever standard, but it's a standard type of exit agreement that we would enter into when there is someone that we want to make sure is covered by those post-employment covenants and terms and conditions.
You know, and that's a great segue to Carl. I want to ask you a couple questions about separation agreements. When we were talking about laying off people, when we were talking about mass layoffs or an individual layoff, you can do it in a mass layoff. You can have a person get laid off because there's a lack of work, but we want to make sure we have our reasons for doing that. One of the things mechanically you think through is, do I want to give the person a separation agreement, right? You don't always have to, is my understanding, right? It's not required that whenever you lay somebody off, you do. So the question is, when would you want to enter into a separation agreement? Because they're not required by statute yet. So when will we do it?
Yeah, great question. I guess I would just follow up on what Rob said a little bit in terms of, what the separation agreement really is. And I think the way I look at it in its simplest form, it's really a document that is intended to tie up all loose ends with that employee. I think about the separation agreement as something you really want a clean break with the employee, no loose ends, ideally no ambiguities. So when that separation occurs, everything is predictable and essentially controlled. Really what you want to do is avoid lingering issues. So you don't, as you said, Cliff, you don't always need one. You don't always want one. But in my experience, and my clients who are on this call may have heard this before, is that I really look at, there's usually three reasons why you would enter, from the employer's perspective, there's really three reasons why you would want to enter a separation contract. And one is that the employer is concerned that the employee might sue the employer. So that would be a case where either the employee has already threatened a lawsuit, or there might be some facts surrounding a termination or even a potential termination where the employer feels that they might get sued by the employee. It could be a discrimination claim. It could be any multiple kinds of claims. But if the employer feels they might get sued, and so there might be some liability exposure, the employer's goal, the reason they would enter that separation agreement, is to get a release of all legal claims that employee would have against the employer. And we typically like to include not only claims against the employer, but the owner of of the business. Even if it's a corporation, still, the owner, the officers, anyone associated with the business, other employees. Again, the idea is to tie up all those loose ends. And here the goal would be to get a release of those legal claims. The second situation where an employer might want to enter a separation agreement is if the employer wants something from the employee that the employer does not already contractually have. So where I typically see that is if the employer is seeking a promise from the employee not to, for example, poach customers, not to solicit customers. You guys talked a lot about non-competitions and non-solicitations. I've been in several situations where an employer didn't have a non-compete, did not have a non-solicit, but now it's very important. They wish they had. And so the employer is willing to pay a little bit of money as an exchange in order to get that promise from the employee to not compete or not solicit. I will, it's not unusual for an employer to seek a non-disparagement promise from the employee. So the employee is concerned that, or the employer rather is concerned that the employee is going to go out into the marketplace and badmouth the employer. Sometimes it's worth it for the employer to pay some money in a separation agreement in order to get that. Sometimes an employee might have the secret sauce, so to speak, the secret formula. Employer realizes when they're terminating, gosh, I wish we had an agreement where that secret sauce is not going to get shared. So you can include that in a separation agreement. And there, the goal is to get that thing that the employer wants that they didn't already contractually have. And underlying all this is another way to look at the separation agreement is it's a grand bargain. It's a grand bargain where each party is getting something they don't already have. Usually what the employee is getting is money. Sometimes it'll be a continuation of healthcare benefits, but it's often money or a continuation of healthcare benefits. It could be other things, but so that's what the employee gets in the grand bargain. What the employer gets in the grand bargain is that thing that it doesn't already have, a release or maybe a non-compete agreement. Then the third, and by the way, it's normally the release that the employer's after. Less likely is that the employers want this thing that they don't already have. The third situation where I would say, okay, let's go ahead and to an employer and say, let's go ahead and try to get a separation agreement done is sometimes employers just want to be nice. They want to be good doobies and they want to reward a longtime employee, a really loyal employee, an employee that's been really beneficial for the company. And they say, hey, can we give this, employee, this departing employee some money? And of course, the employer can do that and doesn't have to get a separation agreement in exchange for that money. But, my view is as long as the employer is giving something it doesn't have to give, this bonus or this gift, whatever, there is a chance that a couple of years after the separation, after all the good vibes wear off and the employee is talking to their cousin lawyer who says, boy, did they really treat you fairly? I mean, you might want to, you might want to think about, I think that there might be a claim there. And then, so even though there were all these good vibes at the departure, still sometimes those employees will come back and then make a claim. So my view is, as long as the employer is giving this gift, you might as well get the release of claims in a separation agreement in exchange for that. And you can, you don't have to do it in a confrontational way. You can say, look, we want to give you this gift, but the pointy-headed lawyer, Carl, says, hey, we want you to sign this thing just to kind of document it or whatever. So in those cases, I would get the release, in the sort of a just in case situation. So those are the typical reasons why an employer would want to enter a separation agreement.
Yeah, great considerations. Now, I guess to sum this up, have there been any recent changes that employers should know about what to put in their agreements, or if there's any challenges? I guess I asked both of you that, like, what's a way to make sure we get these things enforced? Because we don't want to put language in here, have everybody go through all the effort of doing it, and then having it overturned because of some development.
Well, Rob, unless you want to jump in, I guess I would say for what I've been keeping an eye on and what I think the relevant changes are, and these are important changes. They're not like huge enchiladas, but it's enough there that you need to definitely keep keep an eye on it. Is there have been some changes very recently regarding confidentiality clauses, non-disparagement clauses, and cooperation clauses. So just a little bit by way of background, I won't go too far in the weeds here, but for many years it was very typical for separation agreements to include clauses that, for one, prohibited the employee from telling anyone about the fact that there was a settlement or the financial terms. We call that that's essentially called a confidentiality clause. It was typical to include a promise from the employee that they weren't going to say bad things about the employer in the marketplace or about its owners or its services or its officers. We call those non-disparagement clauses. And then it was also quite typical to include clauses that required the employee to cooperate in future investigations or proceedings involving the employer. So the employee leaves, MIOSHA comes knocking, or the EEOC comes knocking, or the DOL comes knocking, and that employee had important information, and we really, the employer needs that cooperation. So these separation agreements would say, hey, if something like that happens, you gotta essentially come back and help us. So those were, and employers generally liked these three clauses that I'm talking about, and that changed in 2023. And essentially, the General Counsel for the National Labor Relations Board issued an opinion which essentially stated that the general counsel believed, and the general counsel is sort of the sheriff. That's the person that's sort of enforcing the National Labor Relations Act. She came out with this opinion that said, hey, look, many versions of these clauses that I was just talking about were either unlawful or they were likely unlawful under the National Labor Relations Act. And the general counsel set out a new test that essentially made it harder for employers to enforce these clauses. And the real kicker is that this sheriff, the general counsel said, those rules that I just described, less employer friendly, those apply retroactively. So even if you had those things signed when they were lawful, now they're unlawful or likely unlawful.
Does the NLRB exist? Are we sure that they're actually still there? There's been a lot of developments going on, so I don't know if that actually matters right now. I mean, I think they are in existence, but who knows?
No, they're still there, but they're certainly changing. To your point, I mean, many of these issues that we're talking about here, they're really political footballs, and so when the administration changes, will change the people on the National Labor Relations Board. To your point, the laws themselves usually actually stay the same.
Yeah.
It's just the interpretation and who's doing the enforcement, the general counsel and the DOL. They will change. So so back when this thing changed in 2023, we basically, and you maybe have read some stuff that we wrote, we began advising clients to take these clauses out or at least rewrite them, and to stop enforcing existing clauses that were good when they were written in older separation agreements. And then in this February, new administration, obviously, new sheriff, new general counsel, went and basically rescinded all those 2023 Biden era general counsel interpretations regarding confidentiality, non-disparagement, and cooperation. And the new administration also rescinded another memorandum which had signaled that the National Labor Relations Board would vigorously seek damages for these unfair labor practices. So to your point, Cliff, I mean, they're still there, but the recent messaging coming out from the general counsel's office by rescinding this aggressive enforcement approach of the Biden administration has basically been, we're here, but I mean, I'm burlesquing this a little bit, but they're essentially saying, we're here, but you don't have to worry quite so much about certainly the way things were, in the Biden administration. So the temperature, the tone, the color of all this has sort of changed to where like you say, Cliff, that it's still there, but it certainly looks like a different animal than it did, not too long ago. So the punchline here, what's that?
Well, and what I was going to say is fundamentally, we've talked a lot about, the government enforcement and the government regulations. And I don't want to forget that, enforceability also is a contractual issue, right? You need to have all the things that we were talking about beforehand, reasonable restrictions, consideration, all those sorts of items. But one thing that I really don't want people to forget is when we're trying to figure out what needs to be put into the agreement is the legal obligations based on things like age, based on the things like the number of people that are out there, right? If you let go of a certain number of people above a certain age with that Older Workers Benefit Protection Act, you have other obligations you have to jump through. You have other hoops that you have to jump through, other disclosures and things like that are out there. So, again, we spent a lot of time talking about the ping pong effect with the government agencies, which obviously, it happens. Any administration change is going to change those areas that are out there. But it's also really important to note that the separation agreements aren't a cookie cutter for every single situation, right? You really do have to evaluate the facts and circumstances on it. So.
Yeah,
Rob,
fair enough.
Yeah, I think that's a great point.
Yeah, I mean, yeah, right. They're not, we get phone calls from clients that say, can you just give me like the separation agreement? I'm sure you have one on the shelf. I got to tell you, I have so many different kinds of separation agreements. There's some situations where you want it as simplistic, as few words as possible. You don't want to spook anybody, so it's just so there's some like really bare bones separation agreements. And then as you go up into the C-suite, the separation agreements tend to get much more complicated. In those situations, there might actually be an employment contract that talks about separation agreements and some of the terms of the separation agreement. And so that can change. And to, Rob's point, essentially anytime you have a program, which is really two or more employees that are terminated as part of a program, you need to keep an eye out on getting appropriate releases for age discrimination claims. So when you have a program where two or more people, you have to include special data. And this is something that you absolutely have to call an attorney about. There's some specific data you have to include to get release of the age discrimination claims, like what's the department or unit that is being looked at for the reduction in force. What are the job titles of the people that are being let go? What are the age of the or might get let go, I should say. Then the job titles and the ages of the people that are actually let go. And then on top of that, there's magic language that has to be included to release these age claims. And this is really a bugaboo, the age, this is a pitfall. This is something that you need to look at is that if the person is 40 or older, which, to me sounds quite young, but if they're 40 or older, one, there's magic language you have to include in the release. Two, you have to give them 21 days to consider the separation agreement or the release, really. And then they have 7 days to revoke. It's very easy to get tripped up on these things. And I'm glossing over some of the complicated issues that come up in terms of, oh my gosh, now I have to wait 21 days for this person to sign. Well, you have to give it to them, but they don't have to use it. And this is often a sort of a confusion when you're trying to land a separation agreement. But just
Oh, that's a really good point because I know you draft. Unfortunately, you and I and Rob and a lot of our team here, we have to draft these all the time. People get let go. We do them for a purpose and a reason. But sometimes employers will go out there, they'll just have their standard agreement. They'll have a 35-year-old person they let go and they want them out. They want this thing signed, but they'll have an old agreement sitting around with a 7-day revocation period. So I can sign it now, but then I'm out. I have buyer's remorse. Well, why did you have it in there? And next thing you know, they get out of it and you're in a lawsuit.
Yeah. Yeah. I mean, yeah, there's lots of ways to trip up on that, those special rules for age discrimination. The other thing I don't want to take up too much time here, but in terms of like where the pitfalls are, the things to keep an eye on when you're doing a separation agreement, I'll just give you a short list of things to be thinking about and often come up in when we're drafting these. And for those of you on this call that have worked with me, you'll know I go through a lot of these issues with you is, do you want to characterize this separation as a voluntary resignation? This is something that you can cost you very little, but could be of value to the employee. So this is in the category of what's the employee getting out of this? Again, I said it's usually money. It could be a continuation of healthcare, but sometimes it's like, hey, I just want to be able to say to the outside world, I resigned and I wasn't fired. It might be, look, I just want a good reference letter or a neutral reference letter, or like, hey, I want to know when I, list you as a job reference that I know who's going to pick up the phone over at the employer and what they're going to say. So these are things of value to employees that you can negotiate in these, separation agreements. There's issues related to unemployment. You can sort of, how you write the separation agreement can have some impact, not only on whether or not unemployment will be paid or not, but essentially a discount on the payment of employment benefits, depending on how you structure the severance payments, whether it's lump sum or whether it's over time. You want to be thinking about things like return of property, those clauses that I talked about, confidentiality, non-disparagement, cooperation.
And I also think that it's important for us to consider, what I think our next topic is going to be, the DEI and how some of the changes in the surrounding landscape regarding DEI may impact our desire to get into these settlement agreements and severance agreements and triggering the negotiation of those provisions.
No, that's definitely something we want to look at. And I think we want to transition. And Carl, Rob, I appreciate it. There's a lot to this. I think people sometimes forget the nuances. So I appreciate, again, glossing over a lot of the details that have to go into this, but very important stuff. And I think a lot of people here probably didn't know there were different timetables, considerations, things you can add, subtract, some things that can trip you up. So really appreciate that. But I do want to segue into our next topic, which is DEI. DEI is something I think that's it's been around for a while. We've heard it. What does it mean? What do you have? And I'm going to bring Courtney in here to talk a little bit about this. Courtney, you and I can kind of go back and forth. We've talked about this a lot. It's something that's the pendulum shifts on almost all topics and laws. We've talked a lot about that. This is one that seems to have a major pendulum shifting here, but there's also some bedrock law here. Can you tell me a little bit about what changes you've seen over the past year that have impacted the concept of DEI?
Yeah, so for the sake of time, I'll try to be very brief on this, but over the past year, we've seen the passage of several executive orders. We've kind of touched on it a little bit throughout this update. And those executive orders are aimed at eliminating preferences, mandates, policies, programs, and activities, whether or not they even identify DEI directly or not, that violate anti-discrimination laws from the workplace, for the federal government, contractors, federal grant recipients, right? We've been hearing a lot about that in the news, people who are being penalized, and then private sector employers. You pair that with some ongoing legal challenges that have been kind of carried over from the Biden administration, and DEI programs are under increased scrutiny, and it's really kind of leaving everybody in this place of uncertainty, and where do we go from here, right? So, I think at some point we probably got to break down the executive orders, and I know we're going to kind of touch on those in a little bit. But those are probably having the biggest sweeping impact right now on a lot of our clients.
Okay. So you mentioned those executive orders. Which executive orders should employers really be paying attention to?
I think for the sake of this conversation, there's three major ones to focus on. The first one, I'll just call it EO, Executive Order 14151. That's really geared towards the federal contractors, agencies, and grant recipients. Actually, not the grant recipients, sorry. It just has a good flow, right? And this executive order requires that all DEI and DEIA, which is DEI accessibility, mandates, policies, programs, preferences, all of that whole list for federal governments are terminated. It also instructs that all existing federal employment practices, union contracts, and training policies comply with this order, right? So it's really trying to take out the DEI piece to emphasize anti-discrimination. The second one, and this has a broader impact, is Executive Order 14173. Probably for our private employers joining us, this is the one they've heard the most about. This executive order revokes previous executive orders regarding illegal discrimination and takes action or requires action to eliminate DEI and DEIA mandates, policies, preferences, activities, etc. It also ends the promotion of diversity within federal contract or with federal contractors and subcontractors. And I think the most notable piece, especially for the private employers joining us, is that it mandates the inclusion of a couple of terms in all contracts and grants moving forward. Those two terms, one is, and I'm really paraphrasing here, is that the counterparty or the recipient is agreeing not to operate any programs that are promoting DEI that violate any applicable federal or anti-discrimination laws. And then the second part of that is that they are agreeing that they will be in compliance with all respects, with all applicable federal anti-discrimination laws. And they understand that this is a material term to any kind of agreement and any future government payouts to them, right? Based off of any of those grants or contracts. So that's probably the biggest one. Potential, I think, violations that private sector employers are likely to run into or run the risk of running into that would violate this executive order. Think about, if you're engaging in, activity that creates workforce balancing based on a protected characteristic, that would be an automatic violation. Or maybe you're, reserving exclusive spots in your employment chain for members of a protected class or characteristic. So those would be automatic dings under this executive order if you're a private employer or if you're somebody who accepts private funding from the federal government. Or
so Courtney, are you saying that we've heard DEI now for a good 8 to 10 years as being part and parcel of what a lot of employers are doing, but not only that, investors, if you're a private employer, community groups, people in outreach communities, banks sometimes. We've really been shown that this is important in the way that we do business and how human resources should try to do things. Are you saying that we need to really go back now based on the executive orders and some of the changes and look at how we hire and how we promote and some of the programs just to make sure we're consistent? Is that what we're looking at here?
Yeah, I think it just has to be consistent. This goes back to kind of the theme of some of our topics. Everyone is protected. So we've got to show consistency. We can't show favoritism. We have to make sure that our hiring practices, our promotional practices, our recruitment practices, what have you, look at the candidates equally, right? Not giving weight to any particular criteria outside of the scope of the job description. I'm trying to think of even like a performance plan, right? You can't give a better bonus or something like that as part of a promotion or a performance plan based off of a protected characteristic. So there's a couple of things I think that we all need to be thinking about, but I don't think the intention is to do away with DEI per se. I think it's just about we've got to treat everybody on the same page, period.
So the impact, right? The impact of executive orders, anything else you can add on what we should be doing? What do we need to take away from these these EOs?
Well, I think, like I said, so EO 14151, that's really going to just impact your federal employees, your federal employers. That one is going to be more program related. I think the biggest takeaway there is violation of that particular EO is going to result in termination of all equity related grants or contracts. So if you are in one of those contracts or grant agreements, you've got to be really careful to see how this transition is going to impact those dollars coming through. It's also going to impact, DEI accessibility requirements for federal contractors and grantees. So that'll be really interesting. For EO 14173, for private sector employers, even though this does have some federal implications for private sector employers, I think you've got to be aware, you've got to make sure that you're not implementing any unlawfully discriminatory mandates or preferences, exclusions, or workforce balancing when you're making any kind of employment decisions. You've got to take the time probably for your protection, right, to review your policies, review your programs, review any activities that you've got in place to make sure they do not involve any kind of unlawful preferences or exclusions, based on those prohibited criteria that the EOs line up, or lay out.
I appreciate that. And I think what I'd like to do is talk a little bit, because segue from the executive orders into general employment law. We talked a little bit above about what the Supreme Court done, the federal government has tried to do is they've said, look, let's just make this simple. Stop discriminating. Okay. From a federal standpoint, it's really simple. The problem is there have been historic executive orders that have said, in order not to discriminate, you've got to do X, Y, and Z. And what some of these have done is said, yeah, we're going to take those out of here. You're not under it. In fact, if you do some of the things we told you to do before, you're going to be in trouble. Okay. I think that's what the biggest problem is, but that's only for people who are receiving generally some sort of grant or applying for federal funding. But there's also some real world how you apply law. But I will say the more things change, the more they stay the same. I want to go back to the 60s. And when I say the 60s, I'm talking about 1866. In 1866, you might remember we had a war. It was called the Civil War, and there was a law that was put into place. And what it said effectively was, look, you can't discriminate and not enforce a contract based on race. Okay. Now, there's something called Section 1981. We won't get into all this stuff, but Section 1981 cases were really big because what happened was African Americans in the South were having a hard time getting into contracts and people were just walking away and the courts were ignoring them. This law helped enforce those. Pretty busy. Then it kind of went away. All right, and it just nobody really did it. And then it kind of had some other claims and it started coming. Now it's being used pretty consistently by groups saying, hey, you got to enforce a contract, including employment, equally, irrespective of race. And everybody says, well, yeah, we know that was for African Americans after the Civil War, after slavery. Oh, no, that's not what it says the proponents of this new enforcement mechanism. And they've been very successful going after people because there's two things that people have to understand. And I think it's lost. It's always the same. The EEOC has never said that affirmative action is the plan. What they've said is affirmative action is actually an exception to the normal don't discriminate rules. When you put an affirmative action plan together, if you look at their plans, they have been very specific. Either it's got to be a plan put in place because you're the type of employer that has been found to probably have engaged in pretty bad discrimination, so you need to put a plan in. Or you go to the EEOC or Department of Labor and you get a discrimination plan, right? A plan to stop discrimination in your community. And both of those are approved, whether they're voluntary, involuntary. They have massive record keeping, and generally they're short term in nature. So that's always been the law for affirmative action. We're an affirmative action employer, which means we don't discriminate, is really what that means. And if you've got a program for affirmative action, it's because you've either been found to be discriminatory, you think you've been discriminatory, or you've been required under an executive order. So those are the exceptions, and we want to make sure we comply. And that's not going to change because there still are some times when your contracts require, whether it be with the federal government or the state, that you do those things. It's very important. Now, DEI came from a different area. It was more of a social construct to push a movement to say, look, I understand the EEO laws are out there. Let's do more. Let's do better. Let's invest. Let's get better outcomes. And what I think the law is saying is that's great. We should have better opportunities to go out and get a bigger pool of applicants. Let's make sure we're not discriminating. Let's put programs and investments together, but you still can't violate Title VII. And as we've seen, you can't discriminate against any race. And these Section 1981 claims are going to be used by people to say, hey, my employment was discriminated against. Now, there's a higher standard for that. Just so you know, in the federal normal discrimination laws, there's a cap depending on how the size of your company if you get sued, like 300 grand. Section 1981 does not have a cap, so potentially. And so what we've seen is a number of lawsuits against programs that are set-asides just for one group. Scholarship or internship opportunities only for one group. Those are being scrutinized. So if you've got an affirmative action plan that's proper and done right, it's still fine as long as it's approved and as long as it's done the right way or it's under a rule. But things haven't changed. In fact, what's happening is DEI can continue, Title VII can continue, Section 1981 continue, but you can't listen to a consultant who says, let me tell you what I think you should do. You better make sure it's consistent with the law. So that's the one thing I think people need to understand is things haven't changed. There was a big push to get things going. Many of those concepts were actually needed. but some might not have met the requirements. So make sure you're not doing it. People always say, hey, at the end of the year, we always take a look and make sure we got enough people to fit the community's look, right? We have this percentage of females, we have this percentage of African Americans, this percentage of Hispanics and Asians. We want to fit a look that looks just like that. Ooh, be careful with that. That could get you a 1981 suit. It could get you a Title VII suit if somebody doesn't get included if you're not part of an actual affirmative action plan. So, or you're mandated by an executive order or a contract from the state or something of that nature. So just be careful when you're implementing plans that have great ideas, awesome outcomes that you want, but they're not done the right way. And you can get yourself in trouble quickly because there are a number of lawsuits that we've seen this year and last year that have gone down that path. And there are well-funded groups who are putting money into that. And so that's just the way it is. And as Tony was talking about earlier, there are changes in those laws. So, Courtney, again, appreciate it. A lot of work, a lot of things, as always with all of our people, if you have any questions, please reach out. And I want to briefly talk about workplace accommodations. Tony and I had talked earlier about a number of these religious accommodation change that had come up. And I talked about the Logic staffing case out in Seattle where an applicant had asked for, prayer, and the EEOC and that employer actually, this was really simple. Hey, can I have a couple minutes to go pray? After he was going to get the job, look at great applicant. They said, yeah, no. And he said, well, I won't even go that far. $217,000 settlement with the EEOC. Okay. That's a big deal. I think you went over a lot of this stuff, Tony, with the religious accommodations. The pregnancy discrimination, I know you've looked at this as well. And tell me if I'm wrong. One of the things that's happened is we've had the Pregnant Workers Fairness Act. Really something employers need to know about. I know we're getting late in the day here, but if you're still listening, if you're still with us, I want you to understand how important this case is. And Tony, chime in if you think there's anything else we can talk about, but you have to accommodate people who are pregnant, not just because they had a child, but because they're having symptoms related to pregnancy. And this had some new rules that were put out under the law last year. And let me tell you, these rules are different than what you're used to with regular accommodations. You have to accommodate like usual, but in addition to the accommodation, there are limits on the type of documentation you can ask for if you already can see the problem or if you've already been told about it. People can say, I want to come in late because of morning sickness. People can say, hey, can you take away for a short period of time an essential function of my job? Remember, in disability discrimination, we go back and forth, right? Somebody says, I have a disability. And then I go back and I say, well, as the employer, I know you got a disability. Give me some documentation from your employer. You want this accommodation. How about I give you this? Because it still does what your doctor says. That's not the case anymore. Well, pregnancy discrimination, you can't, unless you can show a true undue hardship, give the person your favorite accommodation. You can't make them go out on a leave if they don't want to go on a leave. And more importantly, usually a person has to perform the essential function of the job with an accommodation for a disability. But here, the employee can say, hey, for a short period of time, take away that thing. Let somebody else do that work for me, unless you can show it's a real hardship. That is a significant change. I mean, a major change. A temporary suspension of one or more essential functions of the job. And an example would be, I'm having trouble getting to work my schedule because of my morning sickness. Usually that's okay. I need time off to go to the medical appointment. Yeah, well, work around it. I need more bathroom breaks. Again, these are things right there in the statute. So I think, Tony, if you have anything else to add on that, but I think those are some pretty big changes in what we're used to in the accommodation world.
Yeah, they're huge changes, like you said. You're essentially taking away an essential function of the job. And the EEOC has come out and they basically said there's some automatic accommodations that you should basically always provide in these circumstances. So more water, food breaks, restroom breaks, standing or seating options, tweaks to the uniform, minor schedule changes, light duty, time off for prenatal or postnatal visits. So these are like, you shouldn't be asking any documentation for any of these requests. They should be granted no matter what. So it's it's a little bit different than the ADA process, which requires a little bit more, hey, give me your medical documentation, let me figure out what you got, then we'll have a conversation about accommodations. It's not like you mentioned, Cliff. It's much more accelerated. And the EOC kind of frowns on asking for documents, and you better be providing an accommodation on an expedited basis.
I agree. Yeah, I think that's it. And it sort of segues into the disability accommodation, the give and take. And I want to give people a little flavor about some of the developments that are going on and some examples. The law hasn't changed, but the enforcement might be a little bit different than what you're used to. And I'll give you an example. There was a EEOC settlement earlier this year, not too long ago, $77,000 actually for a company where a person said, look, I've got this disability. It's a lot of work for me to walk across this giant parking lot. I park in this parking lot. I walk all this way. I've got this disability. It hurts. It hurts. And because of that, I'm asking to work from home. And at first they said, yeah, okay, you can work from home. But now we're making everybody come back into work. And the guy says, well, I still want to work from home. And they let him do it for a little bit. And then they said, you know what? You got to come to work. Now, there were certain factors in that case. And the EEOC and then went back and they said, you know what? It wasn't going to cause you an undue hardship under those facts. And we're going to go to court and we're going to try you. And they end up settling for 77.5 plus they had to do some other training and some notices. In another case, the EEOC came to a $250,000 settlement where a blind employee comes to work and says, look, I'm legally blind. Can you buy this software so that it helps me read things? And they just simply said, yeah, no, not going to do that. It costs too much. Don't want to look into it. And they said, well, can you just look at it? Can you just look at this program and talk to them? And they said, no, we're not going to do that for you. They sued. They said it was, basically discrimination. And they said, yeah, it's a pretty big deal, 250 grand. And they said generalized conclusions of what is and isn't reasonable or whether you can or can't afford it isn't going to support a claim that it's an undue hardship. You've actually got to look into it. Big deal. We needed to make sure we go through that interactive process. I had a gas station case just came down, $35,000 settlement because a lady said, look, I need an accommodation in my schedule. I got this disability. I need an accommodation. Can you work with me? They said, yeah, no problem. We'll give you 6 hours a week. She's like, well, I need more than 6 hours a week. I just want you to work with my schedule. They said, no, we did. We gave you 6 hours. You're fine. She quit, said it was constructive discharge. EEOC said, no, you got to do a little better than that. You got to go back and forth with them and see if you can work with them. Facts matter. The case matters. And then just this week, I saw a Virginia case for $20,000 for a guy who had a cardiac problem, heart issue. They put some sort of defibrillator in him, and they said, well, you can't drive a truck. And he said, well, I can drive a truck. I got a clearance from my doctor. You can't. It's not safe for you to drive that truck. Took him out of the truck. They settled for $20,000. Again, not every case is the same, but I just want to say that's why you go through the true interactive process. Give me your doctor's note. What's going, just like Tony was saying, go through the issue, make sure we're doing it the right way before we say no, before we get to that point.
And on that point, Cliff, I was actually looking at a Texas case as well that the court looked at the amount of time as well that they were engaging in the interactive process. And the court said, no. 6 months went by and you were asking for documents. You didn't believe the medical documentation. So you sent them out for an IME and then there were issues. And basically at the end of the day, it was 6 months from the time an accommodation was requested before you gave the accommodation. And the court found that was bad faith. You don't have to act with maximum speed, but like they're asking for an accommodation here. You got to move a little bit quicker. So I just would reiterate everything you just said. And on the religious accommodation side, I know we talked about it a little bit before. Title VII doesn't specifically require you to engage in the interactive process, but the EEOC's guidance said basically, yeah, you should. And it's a little bit of so you're not going to ask for documents in a religious accommodation case. But it's interesting because you need enough information to show the conflict between someone's sincerely held religious belief and your work policy, whether that's grooming, whether that's dress code, whether it's they need Sundays or Saturdays off. So the conflict there. So if someone says something to you and you don't have enough information to figure out what they're talking about, if it is truly a religious accommodation, then you can ask and follow up. But it can't tip over into I've never heard of that religion before. I don't believe that's a sincerely held belief. The EEOC and the Supreme Court have come out and said basically, they're not in the business, and the courts aren't in the business of deciding whether someone's religion is proper or whether their belief is sincerely held. So you can ask for enough information to develop that conflict, but don't let it tip over into, yeah, I don't believe you. I need a document from your priest or your clergy member. That's a no-go.
Yeah, great points. The religious discrimination is going to continue to be probably the hallmark of the EEOC for a while. I think they're really making sure that when people say I need time off for this or I need this accommodation, you have to listen, and you better be able to show it's going to cause an undue hardship. And I'll give you an example before we move on. That is, if you say, I'm sorry, I can't do it, they're going to say, did you ask for volunteers to help out for a schedule? Did you look for volunteers? And if you say, well, it's going to cost me a little bit of money in overtime, that's the old way of looking at things. It's not enough. I got a union contract, goes by seniority. Well, did you talk to the union? Did you, in the past, have you worked with people? There's a lot of questions. They're going to say, past practice, what did you do? Did you just say no because it's hard and you don't want to? That's going to be a problem. So thanks, Tony, again. Appreciate it. A lot of stuff to cover here. Obviously, we could do this all day on each of these cases, but I just want you to know what the issues are. Now, the final topic that we want to talk about here, we've got over 3 minutes to talk about this. So I'm sure we're going to cover everything that you ever wanted to hear about.
We'll make it work.
One of the topics you probably heard from this law office enough from one of our panelists or many of our panelists, which is ESTA. For the most part, I think most people are on board. All right. ESTA is what it is. It's been around, a shock to the system at one point in time. Now people have kind of settled in and they've said, okay, I've got it mostly right. I'm not sure if I'm 100% right because there's been no cases on it yet. Right. We've got some guidance, but we don't have 100%. But maybe Courtney, since you're here to talk a little bit about this ESTA, Earned Sick Time Act, I think something's coming down the pike pretty soon, though, that's going to be different than what we've been talking about the last couple of months.
We've been monitoring ESTA. The biggest change that I can really speak to right now, right? And Cliff, please jump in for me here if you have any additional insight. But the biggest thing we've been monitoring, because there hasn't been that definitive case law or judgment or any kind of proposed bills from the legislator, we've been monitoring the FAQs. That's to me been the biggest thing that keeps throwing a wrench into things. Once we feel like we've gotten settled with ESTA, that's what keeps changing. It's not really clear where the state is coming up with some of their guidance that they've included in the FAQs, but that's been the biggest thing that we've been monitoring and having to kind of pivot accordingly as we navigate our clients into compliance, right? Because they're seeing these FAQs, they're seeing this guidance, and they're thinking to themselves, well, gosh, now we've got to change our classification, or gosh, is this employee a volunteer, or is this employee, captured over here? So we've had to monitor that quite a bit as we wait for, those case law decisions to kind of come rolling in.
Now, the other thing that's coming up October 1 is small employers are now going to have to get into compliance, right?
Oh yeah, that's a deadline that is coming up right now. For most employers, this went into effect immediately, right? And the cover in like first thing in the morning on February 21st of this year. And then you got those fortunate small employers or small businesses where this doesn't kick in until October 1st. So right around the corner. And I do think that that's going to prompt a lot of claims or complaints being filed, and then we might start seeing some of that guidance we've been seeking from the courts on how to enforce this. There is like another timeline population in this group for small businesses. If you're an employer who you're a small business and you've only had one or more employees since I think it's February, I want to say, what is it, 22nd of 2022, you've got 3 years before you can actually start enforcing ESTA. So that's, you've got that little buffer as well if you're that kind of small employer and have only one employee since that time frame. But those are the only deadlines I can think of right now.
Yeah, I appreciate it. I mean, there's a lot of questions on ESTA. We're still fielding those. It is developing for small employers, especially. If you have any questions, reach out to us. It is a technical law. It's a new law. Like all laws, there's a little bit of changes, but we've done a lot of work. All of our attorneys, I think, on this call here have helped out clients, and we work collaboratively to help out. another major law that's come out is some significant changes to the Youth Employment Standards Act that are going to be coming out. Mike Bloom, who's on this call, does a tremendous amount of discussions on that. And I would recommend, if you have any questions on the new way that you're going to have to get yourself ready. Everybody's going to have to get on the new portal that's going to be held through the state instead of the school boards. There are a number of issues that you're going to have to get up to speed on. Again, everybody's a little bit different. Your industry is probably going to be different, but I would strongly recommend with the changes to that statute, if you use youth and you are an employer, talk with your counsel before you go in and get those people signed up. So, because it's important that we know the changes. With that, we're right at 11:32. We're a little bit over. I really appreciate everybody joining. I know we had a lot of material, short period of time. Thanks everybody for coming, attending. All the attorneys here are very happy to be here. Want to help out. If you have any questions, reach out. I know there's a number of question and answers. We just can't get to all of them, but I do know that we're going to try to get back. We're going to look it through and try to get back to those questions and answers and respond back if we can. Some of those will be a little bit more detailed, so we won't be able to just say, hey, off the cuff. It would be more of an advice issue. But again, we really appreciate the opportunity to talk with you. We're going to try to post this on our website. We'll try to do it in segments so you can kind of look back if you have any questions. You can kind of go back and review it. But as always, when in doubt, just give us a call. And with that, appreciate everybody. Have a great day, and thanks for joining us.